Judge Bork, this distinguished panel of introducers, my colleagues, and the public. And I'd like to take just a moment at the outset to explain how we're going to proceed today and from here on, I hope. It's the ordinary practice of the committee in a hearing like this, Judge, to have opening statements from all of my colleagues, and then to invite the presenters of the nominee to speak, and then ask the nominee for his or her statement. And but we're going to change the beginning just a little bit today to accommodate some very busy and quite frankly very important people. Today you have a distinguished panel of introducers that are here, and what I'd like to suggest that we do, and I've checked this with my colleagues, I believe they're all in agreement, is that what we will do today is, even though every senator will have up to 10 minutes to make an opening statement, I will, for the time being, forego my opening statement. And I understand the distinguished ranking member, Senator Thurman, will also. And then we will yield to President Ford, and it's a great honor to have you here, Mr. President. Yield to President Ford and distinguished members of the Congress who will be introducing you. And then we'll come back to opening statements, either Senator Thurman or Senator Kennedy, whomever wishes to proceed next. Finish our opening statements, I suspect that after the introducers and the opening statements, that will quite frankly take the better part of the morning. So I beg your indulgence, Judge, to sit through all the flattering comments that you will hear and all the questions that you may hear raised. And then we will reconvene approximately an hour after we finish. My hope is we'll finish by 1 or earlier, and we'll reconvene at 2. And at that time, I will make a brief opening statement. I will invite you to make your statement, and at that time, hopefully, introduce your very lovely family that I have an opportunity to meet just a few moments ago. So that's agreeable with my colleagues without any further waste of time. I welcome you, Mr. President. It truly is an honor to have you here. As you know, on both sides of the aisle, you've had nothing but friends, and we miss you here in Washington. And quite frankly, most of us envy you. Not only that you have been president, but that Senator Dole and I don't care much about that, but not only that you have been president, but that you seem to be flourishing in the status of a former president as well. Mr. President, please, your opening statement.
Mr. Chairman, distinguished members of the Senate Committee on the Judiciary, first, Mr. Chairman, I thank you for your very kind and generous introduction. It is a very high honor and a very rare privilege for me to return to Capitol Hill and to appear before this distinguished committee of the United States Senate. Although I never had the privilege of serving as a member of the United States Senate, I did have the great honor of 25 and a half years as a member of the House of Representatives. During my years in the House, my 9 months as President of the Senate and 2.5 years as President of the United States, I had an abiding respect for the Senate, especially its unique and special responsibilities under the Constitution. In addition, in my 28.5 years in the nation's capital, I developed warm and treasured friendships with members of the Senate on both sides of the aisle. I am pleased to see some of these cherished friends on the panel on this occasion. My appearance before the committee is for the purpose of introducing the Honorable Robert Bork, Judge of the United States Circuit Court of Appeals for the District of Columbia, who has been nominated by President Reagan for service as an Associate Justice of the Supreme Court of the United States. Under the Constitution, Article 2, Section 2, the President has the authority and the responsibility of nominating an individual for the position of justice on the United States Supreme Court. The Senate, under Article 2, Section 2, has the duty of advise and consent for presidential nominees to the Supreme Court. During my service in the presidency, I had the opportunity and the honor to propose to the Senate an individual for confirmation to serve on the nation's highest judicial body. I consider the nomination of a Supreme Court justice one of the most important responsibilities of a President of the United States. It is vital that the nominee selected be of unquestioned character, broad training in the law, in-depth experience in the legal profession, and have a capability to analyze the facts with objectivity and articulate one's decision on the basis of the law and the Constitution. It was my honor and privilege as President to submit the name of Judge John Paul Stevens to the Senate for confirmation. The then U.S. Attorney General, Edward Levy, was invaluable in the selection process to fill this vacancy. We extensively reviewed Judge Stevens' background in private practice as a United States District Court judge and as a judge of the 7th Circuit of the Court of Appeals. Attorney General Levy and I personally read a number of his decisions. On the basis of his superb qualifications, I submitted his name to the Senate, and he was promptly and overwhelmingly confirmed. I am very proud of Justice Stevens' superb record on the Supreme Court for the past 12 years. While I have not always agreed with Justice Stevens, such differences in no way whatsoever undercut my faith in his effective and dedicated service on the Supreme Court. Because I have such high regard for Justice Stevens, I am pleased to note that on July 17, 1987, while attending a meeting of lawyers and judges in Omaha, Nebraska, Justice Stevens stated that Judge Bork, and I quote, is a very well-qualified candidate and one who will be a very welcome addition to the court, end quote. I have known Judge Bork since the mid-1960s, when he was a distinguished faculty member of the Yale University Law School, my alma mater. While teaching at the Yale Law School for 15 years, he held 2 endowed chairs in recognition of his achievements as a scholar. He is an honored graduate of the University of Chicago Law School and managing editor of the Law Review. Prior to law school, he served in the United States Marines, and while in law school, interrupted his legal education for a second Marine Corps tour. He had broad experience in private practice as a partner with Kirkland & Ellis, a nationally known prestigious law firm. My friendship with Robert Bork expanded during his service as Solicitor General, 1973-1977, while I was the Republican leader in the House of Representatives, Vice President, and President. For the record, he was unanimously confirmed as Solicitor General. Just months into the job as Solicitor General, Robert Bork was faced with a crisis not of his own making. President Nixon, during the Watergate investigation, ordered the dismissal of Special Prosecutor Archibald Cox. Judge Bork, when thrust into a very difficult situation, acted with integrity to preserve the continuity of both the Justice Department and the Special Prosecutor's investigation. I think in retrospect, that history has shown that his performance was in the nation's interest. When I became president, August 9, 1974, I requested that he stay on as Solicitor General, and he distinguished himself as the principal government advocate before the Supreme Court during my administration. The Ford administration and the nation benefited enormously from this outstanding service. I was especially pleased that President Reagan nominated Robert Bork for Judge of the United States Circuit Court of Appeals for the District of Columbia, and that the United States Senate confirmed him unanimously just 5 short years ago. In my judgment, in my opinion, Judge Bork's record on the bench has been exemplary. There are 4 kinds of occupations that a lawyer can have: private practitioner, law professor, government lawyer, and judge. Robert Bork has distinguished himself in not one, but in all 4 endeavors. A renowned federal appeals court judge, former Solicitor General of the United States, professor of law at Yale University, and twice a partner in one of the nation's leading law firms. Judge Robert Bork is uniquely qualified to sit on the United States Supreme Court. It is therefore my distinct honor and great pleasure to introduce to this distinguished committee a man who, as Chief Justice Berger noted, may well be the most qualified nominee to the Supreme Court in more than half a century. Mr. Chairman and members of this distinguished committee of the United States Senate, I strongly urge affirmative committee consideration and favorable approval by the United States Senate. Thank you very much, Mr. Chairman.
Thank you very much, Mr. President. Now we'll go to the Senate Minority Leader, Republican Leader. Senator Bob, you are welcome. I understand you have a very tight schedule, Mr. President. You do not feel required to stay. I mean, you're excused. Yes.
I wonder if the chairman would indulge me the president a question, seeing that he's going to leave. It'll only take 30 seconds.
Mr. Chairman, I am delighted, and I would be pleased to stay and respond to questions if you or other members of the committee would like to pursue that. I have a schedule, but nothing today is more important than my presence before this committee on this vital matter. So I'm delighted and honored if somebody on the committee would.
Well, Mr. President, maybe to accommodate your schedule, I don't have any questions, and I don't think anyone else does. Obviously, Senator Deaconson does. Has one.
Mr. Chairman, I'm sorry to indulge the committee, and I know this is different than what you and I talked about the day before yesterday. I did not realize I have any questions, but I read your statement this morning very careful, Mr. President, and I wanted to ask you if you have read any of the opinions of Judge Bork since he has sat on the circuit court in the district.
I have read a limited number. I have read various analyses, pro and con,
of his opinion.
Of those opinions. I have read those that have been submitted to me by the people that are favorable, and I have taken the time to read some of the analyses that are critical.
And Mr. President, have you had a chance to read any of his law review articles, in particular the Indiana Law Review article of 1971, or any of his other law review articles that are controversial nature?
I have not read individual law review articles. I have read synopsis of some of those articles.
Thank you, Mr.
Comments,
President.
pro and con, by individuals who were interested. Yes.
Thank you, Mr. President. Thank you, Mr. Chairman.
Thank you. I appreciate your indulgence. Mr. President, as I said, you're welcome to stay, but there is truly no need. I know you have a schedule, and I don't mean to imply in any way that this is not the single most important thing to you. I understand that, but I think Judge Bork is well represented. You're welcome to stay. If your schedule dictates that you go, please. I thank you very, very much for being here. It's been an honor for the committee. It's not often we have a a former president before this committee. It's been a great
Thank you
honor.
again, and unless there are any questions, I appreciate very much.
We have no further questions.
Fine.
Thank you very much, Mr. President. Now we will proceed with Senate Republican leader, Senator Dole, who's been a member of this committee for many years, and welcome back, Bob, and please proceed.
Mr. Chairman and members of the committee, I'm certainly pleased to have this brief opportunity, and I will be brief. I know the committee has a lot of work to do. I want to thank my former House colleague and a friend of mine for over 25 years, President Ford, for being here this morning. I think he does add a great deal to this hearing. He does have the respect of Republicans and Democrats, and has had as far as I can recall, so I'm certainly pleased to see him again. And I agree with the comments made earlier by the chairman about former presidents and future presidents. But I am very pleased to be here for a couple of reasons. There's more than little fortuity in the timing and location of these hearings, because in 2 days we will be celebrating in Philadelphia the bicentennial of our Constitution. And that Constitution established, of course, 3 branches of government: the executive, the legislative, and the judicial, each with a role to play in governing our nation. And all throughout this past summer in this very room, members of Congress explored the complex and dynamic relationship between the executive and the legislative branches of our government. And in the process of doing this, they raised the level of public debate on that relationship. And now the committee will explore a different aspect of our constitutional system: the proper scope of the Senate's role in the selection of Supreme Court justices. In Judge Robert Bork, the President has found a man of unquestionable ability and integrity. His professional background made him a leading and obvious candidate for the Supreme Court even before Justice Powell resigned. And those who have opposed his nomination and may oppose his nomination in the future, in my view, have conceded that much. And many have focused their attention on his ideology. And in doing so, they have found different reasons why they now must oppose, or why they might oppose in the future, Judge Bork. And I think this hearing is going to be of tremendous significance. Let's face it, we're all politicians. And we know that 1988 is next year. But I've got to believe that Republicans and Democrats alike take this responsibility very seriously on this committee. There are going to be some tough questions. Judge Bork knows that. Judge Bork is prepared for that. And I believe in the final analysis that he's going to be the key factor in this whole confirmation process. Some of us have indicated our support, and some of us have indicated our opposition. But I've been pleased with what I see developing. I think we're going to have a very objective effort, obviously, by this committee. And I would hope when this nomination comes to the Senate floor, as I believe it will, that we can move with dispatch and keep it on the same high plane. And I know that's going to be the effort of the distinguished chairman and the distinguished ranking member, Senator Thurmond, and others who will be involved in that debate. And I would hope that as part of the leadership that I can be of assistance along with Senator Byrd. Now, there are a number of issues that don't lend themselves to easy answers or instant analysis. They certainly don't lend themselves to slogans or statistics. And I would ask the committee and the American people to take the time to understand Judge Bork's approach to the Constitution, And that approach is based upon judicial restraint, the principle that judges are supposed to interpret the law and not make it. Now, Judge Bork didn't invent this concept. It's been around for a long time. One of the most eloquent advocates was Oliver Wendell Holmes. And similarly, his views on many cases are not original. As I understand, and I haven't read all the articles, but his writings on the right to privacy are difficult to distinguish from those of Hugo Black. So there are many similarities, and I'm certain the committee will go into case by case, law review by law review, and you will make the final determination. Now, it's been some time since this nomination was made. And I would say at the outset, some of us were critical of that. But I would guess in retrospect, it may have taken that much time with the August recess to prepare for this very important hearing. Let's face it, there's tremendous interest across the country, wherever you go, and some of us go a lot of places. This is generally question number 1 or number 2 in any town meeting in America. So the American people are tuned in. The American people are ready for a fair and impartial, tough hearing. And I've got to say, Judge Bork, you're probably going to have one. And I know you're prepared for it. And I want to join my colleagues here to indicate my appreciation for having an opportunity to help introduce Judge Bork this morning.
Thank you very much, Senator. And again, I know your duties are exceed those of us on the committee here in your leadership position. You're welcome to stay, obviously, but we understand if you...
I'm going to stay for the other 2 states and head for Iowa.
My next-door neighbor in this building is a senator from Missouri, Senator Danforth. Welcome, and if you would proceed.
Mr. Chairman, thank you very much, members of the committee. Normally, presidential nominees ask senators from their home state to present them to Senate committees. Judge Bork resides in the District of Columbia, so he has turned to the next available option and has asked a former student of his to be here today. His first year on the faculty of Yale Law School was my final year as a student there. He taught me all I ever knew about antitrust. And for those who wonder about his compassion and humanity, I passed Professor Bork's course. Mr. Chairman, I'm genuinely honored to be here today. 25 years after that law school class, my memories are dim about the details of antitrust law. But I have a clear recollection of Bob Bork, the teacher. Even in his first class, he was a first-rate professor. He has since told me that he was panicked when he stood before that class. He certainly didn't show it. By every indication, he loved teaching. His eyes sparkled. So did his sense of humor. He delighted in saying things to provoke responses from his students. Far from playing the self-important pedagogue, Bob Bork delighted in the give and take of the classroom, in the clash of ideas. He did not require us to receive his thoughts as revealed truth. He taught us to think for ourselves. He held strong views. Every good law professor does. But he used those views to evoke a response from his students. He encouraged argument. He respected dissent. This to him was the joy of classroom teaching. Judge Bork has said that his own philosophy of the law has evolved over the 25 years since I knew him in class. He is the best one to explain just how that evolution occurred, and I'm sure he will do just that, clearly and unequivocally. My point is simply this. Those who say that Judge Bork is an unyielding ideologue are not describing the man I know. In my experience, unyielding ideologues do not resemble Judge Bork. They do not encourage dissent, they do not have a sense of humor, and they do not evolve in their own thinking. Mr. Chairman, having made these comments about Judge Bork the person, I do not believe that the Senate's decision will or should be made on the basis of personality. The issue before us is far more fundamental and far more important than that. In this confirmation, we in the Senate will be expressing our views on the role and power of the United States Supreme Court. The straightforward issue is the readiness of the court to strike down the acts of the legislative branch of government, federal or state. The power of the courts to nullify legislation is restrained only by the court itself. As Justice Hughes once said, the Constitution is what the judges say it is. A court which is willing to read novel meanings into the Constitution has the power to do so. Judge Bork is an advocate of judicial restraint. His view, as I understand it, is this: if the Supreme Court strikes down a legislative act, its decision must be based on sound legal reasoning, not on the personal opinions of the court about the wisdom of the legislation dressed up in legal terminology. Judge Bork's judicial philosophy is open to fair debate by able people of goodwill. I happen to agree with Judge Bork's view of judicial restraint. Some do not. Some believe that the court should stand at the ready to supplant legislative opinion with its own. Whether one agrees with Judge Bork or disagrees with him, his is not a novel position. It reaffirms the faith we place in the democratic process. Judge Bork stands in a highly respectable tradition, including such giants as Justice Frankfurter and his late colleague at Yale, Professor Alexander Bickel. He would state his position with great intellectual force in the Supreme Court, but with good humor and civility. Mr. Chairman, in this bicentennial year of the Constitution, the Senate now commences a most important debate. It is not about Judge Bork the person, however much I like and respect him. It is about the power of the Supreme Court and how, if at all, it should restrain that power.
Thank you very much, Senator. We welcome from the House Congressman Hamilton Fish. Congressman Fish, welcome. Please proceed.
Thank you, Mr. Chairman, and members of this distinguished committee, and I greatly appreciate your courtesy in inviting me to participate in these very important proceedings. Up to now, I didn't realize why I was invited, but having heard the reasons for the other people being present, I realized that in this ecumenical spirit, they wanted one Harvard graduate on this panel. Well, like yourselves as members of Congress, as a member who serves on the House Judiciary Committee, I naturally have a strong and abiding interest in the quality, effectiveness, and constitutional legitimacy of our federal judiciary. There are many relevant factors to consider in connection with an individual nominated to serve on the United States Supreme Court. Obviously, this includes intellect, legal training, practical legal experience, demonstrated professional competence, and personal integrity. A record of legal scholarship, while historically not always a prerequisite, is also an important consideration when relevant. Finally, and very importantly, if the nominee has prior judicial experience, what does that record reveal, both in terms of legal soundness and judicial temperament? But that is what the Senate confirmation process is about: reviewing these factors, hearing both sides on the merits of a particular nominee, and ultimately deciding in the best interests of our nation. Certainly no one can look at the career of Judge Bork without being impressed with his extraordinary credentials: a graduate of the University of Chicago Law School, a Phi Beta Kappa and managing editor of that institution's Law Review, Robert Bork has twice served on the faculty of Yale Law School and was a professor at that prestigious institution for a total of 15 years. Mr. Bork, as you have been told, has also been in the private practice of law during his career and earned a national reputation as an outstanding litigator. And from 1973 to 1977, Robert Bork was the Solicitor General of the United States, a job universally recognized as one requiring the talents of a lawyer's lawyer. Since 1982, Robert Bork has served as a judge on the Circuit Court of Appeals for the District of Columbia, and during that time has, in my judgment, accumulated a remarkable record. A record I respectfully submit should be most relevant to this committee's consideration. Of the 426 cases in which he has participated, Judge Bork has been the author of the majority opinion in 106 instances. With respect to those 106 majority opinions, it is deserving of emphasis that he never has been reversed by the Supreme Court. Furthermore, of the 401 cases in which Judge Bork joined with the majority, none have been reversed by the United States Supreme Court. In addition, Judge Bork authored dissenting opinions in 25 remaining cases, and the Supreme Court adopted the viewpoint expressed by Judge Bork in those dissents on 6 different occasions. Many have offered the observation that Judge Bork may well have the most remarkable record on appeal of any currently sitting United States federal judge. I think it's a fair conclusion from these statistics that Judge Bork's judicial rulings during these 5 years have not been at variance with the prevailing views of the current Supreme Court. Frankly, Mr. Chairman, I find it personally difficult to reconcile some of the charges that have been levied against Judge Bork with his record since becoming an appellate federal judge. His judicial philosophy, in practice as well as in theory, is fully consistent with traditional American legal thought. For Robert Bork, the role of the judge is to apply the intent of the legislature to a legal fact situation. Following the President's nomination of Judge Bork to the Supreme Court, I reviewed a number of his opinions in the District of Columbia Circuit Court with particular emphasis on matters of great concern to me, the First Amendment and civil rights cases. These cases demonstrate that, in application, the result of Judge Bork's philosophy can often be civil libertarian in nature. They certainly do not disclose a view that our Constitution should be other than contemporary and workable in a modern society. And the citations to that are in my prepared text for you. From his perspective, a judge may not insert his own personal preferences or political philosophy into a case. The media calls it exercising judicial restraint, but Judge Bork states it more clearly as the intellectual rejection of judicial imperialism. That is the term he implies to judges who would substitute their private personal philosophy or private personal views, political views, for that of the legislators who actually wrote the laws. He recognizes that judges are not elected and that under our system of government, it is the elected representatives that write and amend the laws. I have every confidence that these proceedings will allow the distinguished members of this committee to probe and to analyze the remarkable qualifications of this outstanding lawyer and judge. Robert Bork deserves to be judged for the lawyer he actually is and on the basis of how he actually rendered judicial decisions. These hearings afford an opportunity to elicit his views directly rather than leave the record to theoretical speculation. Mr. Chairman, this man is qualified to be an Associate Justice of the Supreme Court of the United States on the basis of virtually every logical criterion. Thank you.
Thank you very much, Congressman. Before I yield to the distinguished ranking member of this committee, I suggest to you all are welcome to stay and listen to us all. Once again, showing your good judgment. Thank you, Congressman. I have 2 housekeeping matters before we move on. I've been informed that there will be a cloture vote, a vote at 11 o'clock. So what we will do is we will not recess in the middle of a senator's statement. We may prior to the next statement being given, recess to go over and then come back so we're not interrupting statements. I yield to my colleague and apologize. I should have probably yielded to you earlier, Senator. You had welcoming remarks, and I apologize. So please take what time you need. Senator Thurman.
Thank you very much, Mr. Chairman. Mr. Chairman, I've had the pleasure of serving with you on this committee, you as chairman and you as ranking member. I've always found you to be fair, courteous, and considerate, and I'm sure that's the way this hearing will be held. Judge Bork, I would like to welcome you and your family here today. I think it particularly fitting that the Senate, in performing its constitutional duty, is considering your nomination to be an Associate Justice of the Supreme Court at the time we are celebrating the 200th anniversary of the Constitution of the United States. Today, the committee begins consideration of this important nomination of Judge Robert H. Bork to be an Associate Justice of the Supreme Court. This is the fourth Supreme Court nomination that this committee has considered in the past 6 years. In fact, I might say that it is the 20th such nomination that I have had the opportunity to review during my 33 years in the Senate. On earlier occasions, I have set forth the qualities I believe a nominee to the court should possess. First, unquestioned integrity, the courage to render decisions in accordance with the Constitution and the will of the people as expressed in the laws of Congress. Next, a keen knowledge and understanding of the law. In other words, professional competency. Next, compassion, which recognizes both the rights of the individual and the rights of society in the quest for equal justice under law. Next, proper judicial temperament, the ability to prevent the pressures of the moment from overpowering the composure and self-discipline of a well-ordered mind. Next, an understanding of and appreciation for the majesty of our system of government in its separation of powers between the branches of our federal government, its division of powers between the federal and state governments, and the reservation to the states and to the people of all powers not delegated to the federal government. There is no doubt that the nominee before us today meets these qualifications. His intellectual credentials are impeccable. Phi Beta Kappa, distinguished professor of law at Yale Law School, and respected author. His experience is extraordinary in academia and as a general practitioner, as Solicitor General, and as a judge for the United States Court of Appeals for the D.C. Circuit. Felt by many to be the second most important court in the country. Judge Bork has a long-standing reputation for integrity and judicial temperament. On 2 occasions, Judge Bork has had his professional qualifications and personal character specifically examined and carefully scrutinized by the American Bar Association. On both occasions, the ABA has given Judge Bork the highest possible rating for his professional competence, integrity, and temperament. Judge Bork is not a new or unknown quantity. He has been before this committee twice previously, and both times the committee and the full Senate have deemed him worthy of confirmation to be Solicitor General and to be a judge of the U.S. Court of Appeals for the D.C. Circuit. It is also worthy of note that both times Judge Bork was confirmed by the full Senate, once when Democrats controlled the Senate and once when Republicans did. There was not a single dissenting vote. In fact, if we were to put aside questions of philosophy and ideology, Judge Bork would in all likelihood already be sitting on the court. However, it is apparent that some would have the issue of philosophy become the standard for whether or not we confirm this nominee for the Supreme Court. This nomination has been delayed longer by any standard than any other Supreme Court nomination in the last 25 years. while opponents mount an ideological campaign against him. Because so much has been said about the question of philosophy and ideology, I believe we should examine that issue within the context of the nominating process. Some have said that philosophy should not be considered at all in the confirmation process. In fact, I have been incorrectly aligned with that position. And others say that philosophy should be the sole criteria. I reject both of these positions. I believe that a candidate's philosophy may properly be considered, but philosophy should not be the sole criteria for rejecting a nominee, with one notable exception. The one exception is when the nominee clearly does not support the basic, long-standing consensus principles of our nation. I want to be very clear about this point. I do not believe that philosophy alone should bar a nominee from the court, unless that nominee holds a belief that is so contrary to the fundamental, long-standing principles of this country that the nominee's service would be inconsistent with the very essence of this country's shared values. Such a nominee's position should be unequivocal and in violation of a basic belief. For example, freedom of speech is a fundamentally accepted principle in this country, but exactly what constitutes speech and whether or not there are limitations on any particular activity are issues on which reasonable people can disagree. Freedom of religion is an accepted tenet of this country, but whether freedom of religion means that a person in the military can wear religious garb rather than his uniform is a matter that can be and is openly debated. That there should be no government-established religion in America is a fundamental principle, but whether that prescribes prayer in our schools is a matter of accepted public debate and commentary. That discrimination based on race or national origin is unacceptable, is a basic tenet of this nation. But there certainly is no such agreement on the use of preferential quotas. I raise these examples not to launch into a substantive debate on any of these issues, but merely to point out that we should not confuse core fundamental principles with the evolving and debatable applications of these principles. In applying this standard, which could lead it to automatic rejection of a nominee, we must be reasonable. We must apply it in a manner which also protects the basic American interest of free and open debate on important issues. As the courts and all Americans grapple with new applications of our principles and new doctrines are created and offered, these evolving decisions are not sacrosanct and above criticism. In fact, debate and discussion of these new ideas is not only welcomed, it is essential. This is a stringent standard, but in my tenure in the Senate, this test has never been used to disqualify a nominee, because no president has ever sent such a nominee to the Senate. To apply a broader philosophically litmus test would put a nominee in jeopardy of being labeled un-American or unfit if he has ever been in a minority position on any issue. It has been said that since the president uses philosophy to pick a nominee, the Senate can use philosophy in evaluating a nominee. A corollary statement should be just as true. When the president does not solely use philosophy to choose his nominee, the Senate should not solely use philosophy to reject that nominee. Historically, presidents do consider philosophy when appointing nominees to the Supreme Court. That is part of our system of government. It is the manner in which the American people have an opportunity to influence the court. But this president was reelected overwhelmingly when the issue of such appointments was a major, well-discussed campaign issue. Because this process is well understood by the American people, any nominee selected by a president comes to the Senate with a presumption in his favor. Accordingly, Opponents of the nominee must make the case against him. That is why opponents of Judge Bork are trying to fit him into some accepted basis for disqualification or create a new one to defeat him. First, Judge Bork's opponents will try to raise questions about his character and integrity. Failing this, they will assert that he is disqualified by virtue of his philosophy, by labeling him as an extremist or outside the mainstream. This, in essence, refers to the purely philosophical test which I have discussed. A review of Judge Bork's record indicates that he indeed is well within the mainstream of legal debate and discussion in this country. His record on appeals is perhaps the best in the country. However, even if a nominee occasionally dissents from a majority view, that should not disqualify him. Although Judge Bork has been in the accepted majority position almost without fail, there is a grand tradition of legal dissent in this country. As Justice Felix Frankfurter said, in this court, dissents have gradually become majority opinions. There certainly is nothing wrong with writing a dissent at any judicial level if it is called for. In fact, integrity demands it. Opponents of this nominee have also surfaced a new theory of balance on the court. That somehow there is a mandated immutable balance of the court. This theory has an inherent problem. When did the court reach the perfect balance? Was it the Warren Court, or the courts which preceded the Warren Court, and which was so greatly overturned by the Warren Court? Further, does anyone really believe that these proponents of a balanced theory would oppose a liberal nominee solely because he had been named to replace a conservative justice? Of course not. More fundamentally, such a theory presupposes that the Supreme Court is infallible when clearly it is not. Do we really want to enshrine for all time every decision the court makes? History gives us many examples of the Supreme Court overruling itself and correcting its own errors. Usually, those who argue balance have certain decisions they do not want reconsidered under any circumstances. On the other hand, I believe the court should be allowed to correct errors it has made. Finally, there is one other issue that should be addressed. I believe, as I have stated before, that the full Senate should make the final determination on all nominations. The confirmation process should not stop at the committee level. The Constitution requires the advice and consent of the Senate, not simply the opinion of any one committee. I am pleased that both Chairman Biden and his distinguished majority leader, among others, have indicated that they agree that this nomination should be dealt with by the full Senate. Judge Bork, welcome again to the committee, and we look forward to your testimony.
Thank you, Mr. Senator. Before we begin with Senator Kennedy's testimony, opening statement, we will have a vote in the middle of it. I'd appreciate it if we not adjourn until the statement is made, and then we'll adjourn all of us at once and come back afterwards. Senator Kennedy.
Morning, Judge Bork. Morning, Senator. From the beginning, America has set the highest standards for our highest court. We insist that a nominee should have outstanding ability and integrity, but we also insist on even more, that those who sit on the Supreme Court must deserve the special title we reserve for only 9 federal judges in the entire country, the title that sums up in one word the awesome responsibility on their shoulders, the title of justice. Historically, America has set this high standard because the justices of the Supreme Court have a unique obligation to serve as the ultimate guardians of the Constitution, the rule of law, and the liberty and the equality of every citizen. To fulfill these responsibilities, to earn the title of justice, a person must have special qualities: a commitment to individual liberty as the cornerstone of American democracy, a dedication to equality for all Americans, especially those who have been denied their full measure of freedom, such as women and minorities, a respect for justice for all whose rights are too readily abused by powerful institutions, whether by the power of government or by giant concentrations of power in the private sector. A Supreme Court justice must also have respect for the Supreme Court itself, for our constitutional system of government, and for the history and heritage by which that system has evolved, including the relationship between the federal government and the states, and between Congress and the President. Indeed, it has been said that the Supreme Court is the umpire of the federal system because it has the last word about justice in America. Above all, therefore, a Supreme Court nominee must possess the special quality that enables a justice to render justice. This is the attribute whose presence we describe by the words such as fairness, impartiality, open-mindedness, and judicial temperament, and whose absence we call prejudice or bias. These are the standards by which the Senate must evaluate any judicial nominee. And by these standards, Robert Bork falls short of what Americans demand of a man or woman as a justice on the Supreme Court. Time and again, in his public record over more than a quarter of a century, Robert Bork has shown that he is hostile to the rule of law and the role of the courts in protecting individual liberty. He has harshly opposed and in public itching to overrule many of the great decisions of the Supreme Court that seek to fulfill the promise of justice for all Americans. He is instinctively biased against the claims of the average citizen and in favor of concentrations of power, whether that is governmental or private. And in conflicts between the legislative and executive branches of government, he has repeatedly expressed a clear contempt for Congress and an unbridled trust in the power of the President. Mr. Bork has said many extreme things in his comments of a lifetime in the law. We already have a more extensive record of his work and writings than perhaps we have had for any other Supreme Court nominee in history. It is easy to conclude from the public record of Mr. Bork's published views that he believes women and blacks are second-class citizens under the Constitution. He even believes that in the relation to the executive that members of Congress are second-class citizens. Yet he is asking the Senate to confirm him. The strongest case against this nomination is made by the words of Mr. Bork himself. In an article he wrote in 1963 during the battle to desegregate lunch counters, motels, hotels, and other public accommodations in America, he referred to the civil rights principle underlying that historic struggle as a principle of unsurpassed ugliness. 10 years later, he recanted his opposition, but in the time since then, he has consistently demonstrated his hostility towards equal justice for all. As recently as June of this year, he ridiculed a Supreme Court decision prohibiting sex discrimination and suggested that the extension of the Equal Protection Clause to women trivializes the Constitution. In Robert Bork's America, there is no room at the inn for blacks and no place in the Constitution for women, and in our America, there should be no seat on the Supreme Court for Robert Bork. Mr. Bork has been equally extreme in his opposition to the right to privacy. In an article in 1971, he said in effect that a husband and wife have no greater right to privacy under the Constitution than a smokestack has to pollute the air. President Reagan has said that this controversy is pure politics, but that is not the case. I and others who oppose Mr. Bork have often supported nominees to the Supreme Court by Republican presidents, including many with whose philosophy we disagree. I voted for the confirmation of Chief Justice Berger and also Justices Blackmun, Powell, Stevens, O'Connor, and Scalia. But Mr. Bork is a nominee of a different stripe. President Reagan has every right to take Mr. Bork's reactionary ideology into account in making the nomination, and the Senate has every right to take that ideology into account in acting on the nomination. Now, Mr. Bork's supporters are understandably seeking to change his spots and deflect attention from the public record of his controversial career. He will have ample opportunity in these hearings to explain or explain away the extraordinary, extreme, and biased positions he has taken. But a switch at a convenient time should not be sufficient to make Mr. Bork one of the 9. Some observers are predicting a bitter battle over this nomination and have suggested that the struggle is reminiscent of the great confrontations over civil rights and equal justice in the past. But those confrontations were inevitable and irrepressible. All Americans should realize that the confrontation over this nomination is the result of a deliberate decision by the Reagan administration. Rather than selecting a real judicial conservative to fill Justice Powell's vacancy, the president has sought to appoint an activist of the right, whose agenda would turn us back to the battles of a bitterly divided America, reopening issues long thought to be settled, and wounds long thought to be healed. I, for one, am proud of the accomplishments of America in moving towards the constitutional ideals of liberty and equality and justice under law. And I'm also proud of the role of the Senate in ensuring that Supreme Court nominees adhere to the tradition of fairness, impartiality, and the freedom from bias. I believe the American people strongly reject the administration's invitation to roll back the clock and relive the more troubled times of the past. And I urge the committee and the Senate to reject the nomination of Mr. Bork.
Thank you. I'd like to ask staff, is the vote still on for 11? Because I don't want Senator Hatch's statement to be interrupted, unless you wish to. It's a cloture vote. It is scheduled for 11. I asked Senator Hatch, would you prefer, Senator, to begin and go until the end, or should we go vote and come back and begin? What would you prefer? If the vote is still on, the committee will recess for 10 minutes or less, I hope. Please, I ask my colleagues, it's going to be a long day. And by the way, before we adjourn the morning session, we will, immediately after adjourning the morning session, we will convene this committee in executive session to vote out the nomination of Judge Sessions. We are recessed for 10 to 15 minutes.
We will continue our coverage of today's hearing before the Senate Judicial Heflin.
Right around I think one question, Chairman.
Into inquiry, when I thoroughly and completely
We will now proceed with the opening statements. Judge, thank you for your indulgence. Neither Senator Hatch and I are the majority or minority leader yet, so we cannot control the business of the floor. And obviously we will be interrupted on occasion through this hearing, but hopefully not too much. I invite Senator Hatch to make his opening statement.
Well, thank you. I want to welcome you to the committee, Judge Bork, and I would just state that I think it's important that potential justices ought to be treated with justice too. Not with inflammatory mischaracterizations, not with distorted statistics, not with misleading methodology leading up to these type of statements and statistics, and certainly not with the selective use of evidence, a lot of which I've seen by your critics in this particular matter. Now, Mr. Chairman, I feel honored to welcome to the committee one of the most qualified individuals ever nominated to serve on the United States Supreme Court. His resume: outstanding law student, successful trial practitioner, leading law professor, esteemed author and lecturer, excellent Solicitor General, and respected judge on the District of Columbia Circa, speaks for itself. Nonetheless, a few details might demonstrate the quality of his life's work. He was not merely one of the top law students at the University of Chicago, but he was the managing editor of the Law Review, as has been stated. He was not merely one of the top law professors for 15 years, but the holder of 2 endowed chairs. He was not merely an excellent Solicitor General, but successfully represented the United States before the Supreme Court in hundreds of cases during his 4-year tenure. He is not merely another appellate judge, but a judge who in at least 416 total cases was never once reversed on appeal. Moreover, the Supreme Court 6 times adopted his dissenting opinion when he had the courage to dissent from the majority of his judicial colleagues. Now, this is a jurist who, in the words of President Carter's legal counsel, Lloyd Cutler, will be counted by history as belonging alongside a few select justices like Oliver Wendell Holmes, Louis Brandeis, Felix Frankfurter, Potter Stewart, whose wife is with you here today, and who I have a great deal of admiration and respect for, and of course her husband, and Louis Powell as well. You've been paid an even higher tribute than even that endorsement, however, Judge Bork. That tribute is found in the witness list of those who have volunteered to testify on your behalf. And I'll just mention a few. That list includes, as we've seen, a former president, a former chief justice, 6 former attorney generals of both parties, 12 top leaders of law enforcement officers, 7 law school deans, 12 leading law professors in this country, 4 top antitrust lawyers, 3 bar leaders, several of your former colleagues at the Department of Justice, and other influential lawyers and organizational heads. If an individual can be judged by the company he keeps, then you are unrivaled. In light of these remarkable credentials, it is hard to understand why your nomination would generate controversy. The answer is found in one word, which is tragic in this judicial context, and that word is politics. Judge Bork is experiencing the kind of innuendo and intrigue that usually accompanies a campaign for the United States Senate. Many senators are experienced at running that kind of campaign, but it has no place in a judicial nominating proceeding. Federal judges are not politicians and ought not to be judged like politicians. The great danger I see in the impending ideological inquisition is injury to the independence and integrity of the Supreme Court and the whole federal judiciary. When we undertake to judge a judge according to political rather than legal criteria, we have stripped the judicial office of all that makes it a distinct, separated power. If the general public begins to measure judges by a political yardstick, and if the judges themselves begin to base their decisions on political criteria, we will have lost the reasoning processes of the law which have served us so well to check political excesses and fervor over the past 200 years. I would ask any American if they would wish to have their life, liberty, and property resting on the decisions of judges who are worried about what the newspaper might say about the case than they are about life, liberty, or property. Now, recognizing precisely this danger, the Senate has refused to employ political litmus tests while confirming 53 justices over this past century. Senate precedent does not support subjecting judicial nominees to ideological inquisitions. Moreover, the Constitution itself does not support that practice. Based on the common sense observation that a diverse congressional body would have difficulty in overcoming jealousies and politics to select the best candidate, the framers in 1787, 200 years ago, just 2 days from now, unanimously voted to vest the nomination power in the president. The Senate, however, was giving a checking function. In the words of Alexander Hamilton, the advice and consent function was to prevent nepotism and unfit characters. The advice and consent function is a checking function, not a license to exert political influence on another branch, not a license to control the outcome of future cases by overriding the president's prerogatives. Despite the lessons of Senate precedent and the Constitution, and in spite of the political damage to the independence and integrity of the judiciary, we are likely to witness a bruising political campaign before your nomination comes to a final vote in the Senate. It is not difficult to outline in advance the type of campaign it will be. In the first place, you will be labeled, even though political litmus tests do not work well with judges, you will be branded an extreme conservative. Of course, this will require some explanation as to why you voted with your Carter-appointed colleague Judge Ruth Ginsburg, who's a great judge, by the way, in 90% of the cases in which you both sat. Or with your Carter-appointed colleague Abner Mikva in 83% of the cases in which you both sat. The next tactic will be to extract a few quotes from 15-year-old articles while you're a law professor and ignore your judicial actions. For example, we have already heard allegations that you might allow censorship of free speech. In fact, anyone who wants to know your views on censorship would merely need to read your LeBron's decision, where you held that the D.C. metro authorities violated Mr. LeBron's free speech rights by refusing to let him hang a poster that was extremely critical of President Reagan. In fact, those posters are going up today. You were even willing to allow the embarrassment of the president who appointed you to uphold his rights. In my mind, actions speak louder than words. Another tactic will be to selectively use evidence. For instance, we have already seen criticisms that your Dronenberg decision denied homosexuals a specific or special constitutional protection. The evidence that these critics consistently ignore is that the Supreme Court reached precisely the same decision and the same result in the Bowers versus Hardwick case. Still another tactic familiar to political campaigns is to accuse you of ethical violations. In that vein, we have heard too much recently about the so-called Saturday Night Massacre. In fact, this was one of your finest hours. You were not the cause of Watergate, but you were part of the solution. As a precondition of carrying out the president's order, you gained a commitment that the investigation would go forth without further interference. You had put a difficult decision. You made a difficult decision on the spur of the moment. Even then, you had to be convinced by Attorney General Richardson not to resign. But the evidence that your decision was correct is history. Because you preserved the investigation, the president was later forced to resign and several others were prosecuted. And the performance that you gave, it seems to me, deserves commendation, not criticism. Now, it will not end there. Inconsistent charges will be hurled at you. For example, you will be called both an extremist and the one vote likely to tip the balance. You cannot be both, unless those making the charges are actually saying that 4 other justices are already extremists. Frankly, it is more likely that those making the charge are the extremists themselves, because the 4 other justices, including one, Justice White, appointed by President John Kennedy, and 2, Scalia and O'Connor, who were unanimously approved by the Senate, unless they're extremists, I don't see how you can change anything there. Consistency, I think you can conclude, will not be a hallmark of this debate. We can discuss likely political tactics for a long time. The important thing to remember is that these political charges betray themselves. As Harding Carter, an official from the previous Democrat administration, candidly observed, quote, "The nomination of Judge Bork forces liberals like me to confront a reality we don't want to confront, which is that we are depending in large part on the least democratic institution with a small d in government to defend what it is we no longer are able to win out there in the electorate," unquote. And that's really what's involved here. And I think he was candid and honest enough to state it in those succinct, candid terms. This is the reason that politics are injected into this proceeding, because many politicians are hoping to win from unelected judges what they cannot win in the Congress or with the people of the United States of America. My fear, however, is that the price of a politicized judiciary is too high to pay in exchange for a short-term policy set of gains. If judges fear to uphold the Constitution due to political pressures or sense that their judicial careers might be advanced by reading that document in the smoky back rooms of political intrigue, then the Constitution will no longer be the solid anchor holding our nation in place during the times of storm and crisis. Instead, the Constitution will just become part of that political storm, blowing hot and cold whenever the wind changes. That is a price that we in this country cannot afford to pay. And I think it's important that the American people understand that here. I commend you for subjecting yourself to this situation. And I commend you for the work that you've done and for the respect that you have from people who are truly learned in the law. all over this country and who set aside political gain. Thank you for being here, and thanks for accepting this nomination.
Thank you, Senator.
Thank you, Senator. Senator Metzenbaum.
Judge Bork, I'm happy to join my colleagues in welcoming you this morning. My vote, Judge Bork, on this nomination will be one of the most important I cast as a United States Senator. The passions generated by this nomination on both sides reflect the enormous significance it has for every American, yes, for our children, for our grandchildren, and maybe even our great-grandchildren. One of the threshold questions we face in this confirmation process is the respective roles of the President and the Senate. President Reagan and his Attorney General have made it a major priority to change basic constitutional principles. The President has proposed a series of constitutional amendments, none of which has made any progress toward enactment. His Attorney General has attempted to persuade the Supreme Court to reinterpret the Bill of Rights. Fortunately, he too has been unsuccessful. Now it is clear that the President wants to revise the Constitution through his appointments to the Supreme Court. No one would question the President's right to attempt to amend the Constitution. But in the Senate, we have every right, yes, we have a duty, to challenge his attempt to amend it by the back door. If the President attempts to change constitutional interpretation through appointments to the Supreme Court, the Senate cannot stand by and passively acquiesce. As the distinguished ranking member of this committee, Senator Thurman, and the President's Chief of Staff, Howard Baker, have both said the Senate has a constitutional obligation to consider the views of a nominee. This is especially our obligation when the President has selected a nominee by reason of those views. Moreover, the confirmation of this nominee is likely to tip the court radically on key constitutional issues. Justice Powell was a conservative justice who followed a pragmatic and careful approach. His mind was not closed. He had great respect for precedent. He did not have a rigid view of the boundaries of constitutional protections upon his retirement. He said, "I never think of myself as having a judicial philosophy. I try to be careful to do justice to the particular case rather than try to write principles." Those who know Robert Bork know he is not Lewis Powell, nor I suspect would he claim to be. Judge Bork categorically rejects any constitutional right of privacy. He believes the government has a right to regulate the family life and the sex life of every American. He believes the government can make it a crime for married adults to use birth control. He has an extremely narrow view of free speech. He does not believe the Equal Protection Clause applies to women. He opposes the constitutional principle of one man, one vote. He would have upheld a poll tax on the constitutional right to vote. He would have upheld a law allowing the forced sterilization of convicts. Judge Bork criticizes judges who make law, yet in interpreting certain statutes, he appears eager to do just that. He would radically reinterpret the antitrust laws in disregard of the intent of Congress, which he considers, that being the Congress, quote,
institutionally incapable of fashioning a rational antitrust policy, end of quote. He would allow giant companies to merge until only 2 or 3 were left. He would eliminate the right of retailers to give consumers a discount on the products they buy. He would ignore Congress's concern about preserving small and independent businesses. Judge Bork says he is neutral and even-handed in applying the law, yet in split decisions involving disputes between the government and an individual, he has voted for the government almost 100% of the time. When citizens have wanted access to the courts, he has always voted against them. Yet when a business is challenging a regulatory agency of the government, he has been on the corporate side in virtually every case. Another issue is Judge Bork's role in the Saturday Night Massacre. A federal court found that his firing of Archibald Cox on President Nixon's orders was illegal, a ruse, in the court's words, to get around the law. Now, new information has come to light which suggests Judge Bork may not have been completely forthcoming regarding his role in this affair. It is important to explore these matters. For what message does it convey if the Senate confirms to the highest court of the land someone who has violated the law? Finally, where does the nominee really stand on the vital issues that he would face on the Supreme Court? A recent article stated that Judge Bork would now have us believe that his controversial writings were the product of inexperience and youth when he tended to go, quote, wild with ideas, end of quote. In fact, Judge Bork was 36 when he wrote that requiring public establishments to serve blacks is a matter of unsurpassed ugliness. He was 44 when he wrote that the First Amendment does not protect scientific or literary speech. And he was 60 when he reiterated just a few months ago his view that the Constitution does not protect our privacy. I strongly encourage you, Judge Bork, to be straightforward and clear with this committee. The record is voluminous. It would be a disservice to you and the country to distort it. These considerations lead me to be very troubled by this nomination. Judge Bork could weaken, literally within a few years, fundamental constitutional freedoms which the Supreme Court has protected throughout its history. The Senate's inquiry follows more than just a consideration of Judge Bork's professional credentials. In the end, each senator must search his or her conscience and ask, is the confirmation of Robert Bork in the best interests of this country?
Thank you, Senator. The Senate Republican Whip, Senator Simpson.
Thank you, Mr. Chairman. Would you do all that? Really? Here we go again. We shall all be witness to one of the peculiar things we see often in this great city. What we now do here is hereby targeted as high drama, the most critical issue of the day, a watershed, the greatest test of the presidency. It's called the 4-H Club of hype, hoorah, hysteria, and hubris. I've served on this committee since I came to the United States Senate. I chaired such a committee when I was in the Wyoming legislature.
a rich honor and privilege to do so. It is this kind of a committee that I enjoy. I enjoy my colleagues. It's been a tremendous privilege. It always commands my utmost respect, admiration, and also my energies. I've served under the chairmanship of Ted Kennedy, always been treated exceedingly fairly and most courteously by him as chairman, and have greatly enjoyed working with him on immigration and some other tough issues. I've served under Strom Thurmond, one of the most extraordinary and deeply respected members of the Senate, a courtly, sincere, and dedicated man. He's been of great help to me and assistance, enabling me to grow and learn in many ways. And now I serve under the able chairmanship of Joe Biden. I've come to enjoy him very much. He is good to deal with. Spirited man of great energies and zest and enthusiasms, and he has been most generous to me. And over the course of those years, I voted for judges presented by Jimmy Carter and Ronald Reagan. Some have been absolutely outstanding. Some seem to me to be steady and thoughtful of whatever party, and they've proven to be so. I think of Ab Mikva and Pat Wall in the other party, superb judges. And there have been some real duds from both sides of the aisle, just like Congress. I've learned much from this committee, from these fine members on both sides of the aisle, but the single most remarkable lesson learned, and yet probably the most disappointing revelation to the layman, would be that I have found that you either pass or kill a bill in the U.S. Congress by the use of a deft blend of emotion, fear, guilt, or racism. We will now debate the confirmation or rejection of Robert Bork with the same deft blend of emotion, fear, guilt, or racism. The American people deserve a lot better than that. That's really too bad. That ought not to be so. Now, go scratch through the records. You will find that I have never objected to a nominee of either party on the basis of ideological grounds alone. Not one. I'm certainly not saying this nominee should be somehow spared ideological litmus tests of both sides. That will be. No complaints. Ideology is a fair game, but surely not the acid test. I do not agree with this nominee on several positions. Abortion is one. He is here to explain in full his position on that. I think he has. You read it honestly. I happen to feel that this deeply intimate and awesome human decision should be a woman's choice. Hopefully it can be made with the concurrence of the spouse, if one, and pastoral counselors or physicians, but it should be her choice. Too bad that has to now be the litmus test here. Twice you passed the confirmation of the U.S. Senate. Twice, unanimously, twice. I hope people remember that. They must have new ground rules now over at the American Bar Association. I paid my dues there for 18 years. They designated you as being, quote, exceptionally well qualified in 81, the highest rating they can give. Obviously, they're a rather forgetful lot over there. And I think at one time or another, every single member of this committee has either toasted the ABA to the high heavens or trashed them royally, depending on just how they rated one of their particular favorite nominees. And now you're going to have to pass some other tests. You used to give them, now you're going to pass them. Tests about abortion, affirmative action, civil rights, rights of privacy, homosexuality, contraception. I haven't heard it said yet, but the case that they speak of here with great passion that you described as nutty. Nutty. I think it was nutty too. So maybe we'll get to the truth somewhere in all this stuff. Obviously we're going to be picking at a lot of old scabs. Too bad. Who among us here on this panel, we in the United States Senate, are designated as the official scorekeepers of our fellow humans? Who does or does not judge when we get to put aside the mistakes, the utterances, the errors of our earlier lives? And who in this room has not felt the rush of embarrassment or pain or feeling of plain stupidity about the phrase previously uttered
were an act long ago committed. Who of us here can pass that test? And who then are the judges of that? Who appointed them? 3 present sitting members of the United States Senate voted against the Civil Rights Bill of 1964. 3 of our colleagues, along with Bill Fulbright, Senators Irwin, Smathers, the vice presidential candidate of the United States, Sparkman, Long, and Russell. Are these then lesser people than us? Are they less respected? Are they held up to a certain ridicule or to some different test? Of course not. How absurd. All Bork did was write about it. They voted about it. And since this man's name was proposed by the President, the various interest groups have been salivating at the chops. And I note they have been thoroughly engrossed in an exercise that must be the epitome for a lawyer, poring over non-unanimous decisions. What an exercise. Send them out to practice law for a few days and represent some woman who says she's going to have an abortion or commit suicide. Or wants to get some dude out of her hair that's chopping her to pieces. Or that represents a client that's in a probate before the body's even cooled. Or some cowboy that chewed a guy's ear off. Send them out to real life. Get them out from under their green eye shade downtown and let them do a little work. I referred to them once as bug-eyed zealots. I have no reason to change that opinion at all. Is this a man wholly outside the mainstream of American thought and judiciary theory in America? I won't go any further. There's the witness list. What an extraordinary witness list. President of the United States to Presidential Counsel Emeritus of all, Lloyd Cutler, and everyone in between, including our remarkable former Chief Justice, and Bill Ruckelshaus, and a panel of Attorneys General. Extraordinary array of people. I've always felt that everyone is entitled to their own opinion, but nobody is entitled to their own facts. You have been on the bench. The Senate put you on the bench. The sitting members of this committee put you on the bench, unanimously. And Solicitor General, unanimously. Each and every one of us. And what have you done since? That should be an issue before us. You've written 106 opinions, and none of them have been overruled. I won't go into that. Your 6 dissents, I won't go into that. But I think it's important to notice that Judge Lewis Powell, the swing vote, quote, that you replaced, on the cases where he was voting on your decisions, agreed with you in 9 out of 10 of those decisions. Let's not miss that. Don't let it go off the wall or skip off the puddle. And you have indeed voted with Ab Nikva 82% of the time, or he with you. And Pat Wald, 76%, Harry Edwards, 80%, Skelly Wright, 75%. You must be doing something right. Well, I surely hope we don't spend an inordinate amount of time on words uttered and printed in 1961 or 1964, or articles written in 1979, or speeches made in 54 or 64 or 74, or mistakes made, or opinions revised, or arguments lost and found, and errors made, unless we would all want to go through that particular test. But as the battery of attorneys who have worked up a sweat on this one seem to be gaining all of their material from non-unanimous decisions, I think they really are going to do nothing more in the long run but to be seen as replacing what was originally obviously an intense hostility toward your positions with what may prove to be a trivialization of their own position instead of a strengthening of it. I think we're going to watch that happen. I want to be here. I think it will. Well, there are not many of us here that would like to be at that table, I can tell you. I always get a kick out of the argument, yeah, but we don't have to do that. We're United States Senators. We don't have to pass that kind of test. The voters do that for us. This man is going to the court. I'd sure hate to have someone rifling through the collected utterances and scratchings of Al Simpson. Lord, I did things and wrote things and said things, and Did all sorts of things when I was 20 and 30 and 40 and 50 that I'm not very proud of. And even today, at this magnificent and mature age of 56, I still cross the fine line between good humor and smart aleck. And when I do, I usually get hammered, and I think I usually sometimes deserve it. So here we have before us a man who the American public is going to get to know and see, and I think understand in full context. And you will be subjected to some of the toughest and the easiest, the most appropriate and the most inappropriate, and the most thoughtful and the most unthoughtful, and the most inordinate and inane questioning known to man, some of it laced with cynicism and sarcasm. But you'll be ready for that. I really think you will. And after all, it was you yourself who said in the Ullman case, quote, "Those who step into the areas of public dispute, who choose the pleasures and distractions of controversy, must be willing to bear criticism, disparagement, and even wounding assessments," unquote. I hunch you like to mix it up, and there's some panelists here that just love to do that. Me too. And you're going to get an awfully fine opportunity. And my hunch is you're going to acquit yourself very well. My stronger hunch is that you will make a very fine addition to the United States Supreme Court. And there too, now, I have made a judgment before the hearings are concluded. The confession is made. But the people who know you best, those at the bench and the bar and in academe and those in Congress who passed upon you twice after thorough investigations, will share that view. So ours is the task of advise and consent. Would you be wise, even-handed, fair, responsible, and an intelligent associate justice? Do you meet that test? That's what we're here for. That's what we should be here for. The test is not whether the nominee meets the approval of every single special interest group who just happens to have a Washington office or a hyperactive executive director. That is not the test. Or, worse, a group that has been running a little low on funds since the last guy they strung on the gallows was carried out feet first. And there are a lot of them running around in the village. I hope we don't do what we did the last time with Justice Rehnquist. Seems to be an unpleasant reality that a Supreme Court nominee has every single constitutional protection until he or she walks into this room. And once in this room, unlike a defendant in a court of law, the nominee is not guaranteed any single right analogous to the Miranda Rule or the Fifth Amendment or anything else. Raw meat for every form of accusation, innuendo, and irrelevant and immaterial statement. It's that part of the process that disturbs me greatly and which I believe is unseemly and the dark side of our deliberations. So I hope there will be restraint. I think there will be. We have our work to do. We must be about that in reviewing the work product of this man, Mr. Chairman, and doing so exceedingly carefully and not being delayed by aimless and remarkable volleys fired in order to get that guy, get that man. And we need not sully and trash the high standards of the United States Senate and this committee in our work. I intend to participate, Mr. Chairman, to listen, to hear, to try to understand better, to try to understand the questioners, the opponents, the detractors, and will it be that maybe we can get away where the scriveners will eventually write and the researchers will have finished piling distinction upon distinction upon distinction in non-uniform and non-unanimous decisions and excised words and phrases to make you look like a boob or a madman? Or will we settle in and get to know the essence of Robert Bork, human being, lawyer, jurist, author, debater, professor, and nominee for the highest court in the land? I hope that's what we'll do, and I hope to help assure it. And finally, and I conclude, and I thank the chairman for his courtesy, it seems to me in my extensive readings, and I really have done some about you, that you have grown and learned and listened and probed and debated and argued and challenged and have been involved in that lifelong adventure of what I call creeping maturity. That is a lot better than being lumped together with that great legion of those humankind known as the dead unkilled. And I await your presentation with great anticipation. The chairman and all members of the committee will assure that you will be treated most fairly and courteously. That is the way he does it. So welcome to you and to Mary Ellen and your family. And I can assure you that this will be absolutely the most stimulating class you have ever been in. Thank you very much.
Thank you, Senator Simpson, for that preview of what the committee's about to do. Judge Bork, I guarantee you this little mallet is going to assure you every single right for you to make your views known as long as it takes on any ground you wish to make them. That's a guarantee. So you do have rights in this room, and I will assure you they will be protected.
Thank you, Mr. Chairman.
And I would also like to suggest that we try to keep to 10 minutes like we all agreed, if we could. I've not been calling the clock, but it would be useful if we could. Senator Deaconson.
Mr. Chairman, thank you. Judge Bork, I'm not here to get you or to hurt you or to embarrass you, and my questions during this effort here are going to be far cry from what Senator Simpson seems to depict may happen to you, at least from this senator. For the third time in my short career in the Senate, I'm joining other members to do what I think is probably the second most important obligation we have as senators. I guess with the exception to power to declare war, this is a responsibility that to me rests with us on the Constitution on the highest basis. It's fitting that the Judiciary Committee begins the confirmations of you, Judge Bork, during the week that we're celebrating our 200th anniversary. That is a great day that is upon us this week, as a matter of fact, because my father was a lawyer and a Supreme Court judge in Arizona. I've been involved and interested in the Constitution most of my life, and having served on the Bicentennial Commission with other members of this committee, I've gained a new respect and awareness of what our founding fathers had, at least as I see it. The authors of the Constitution were worried that one branch of government over time could dominate another. To prevent such imbalance from occurring, they crafted a delicate system of checks and balances among the three branches. It is as a part of that delicate system signed 200 years ago this Thursday that we gather here today to implement. Because the Constitution contemplated that the three branches of government be equal, the selection of a Supreme Court justice is just as important as the election of a new president or a new Congress. As a matter of fact, the nomination and confirmation of the Supreme Court justice is a pivotal point of our system of checks and balances. That's why we're all here today. The founders did leave one important decision about the advice and consent procedures for us to decide after the Constitution was in place. What was left unanswered in 1787 was simply this: what were the criteria by which the decision of nomination and confirmation should be made? Much controversy about these criteria have existed over the years, and that controversy remains as great today as I believe it ever was. Some supporters of you, Judge Bork, argue that the Senate should not consider your philosophy and ideology, but should decide only whether you have the appropriate intellect, temperament, and integrity. Some of your opponents, on the other hand, argue that not only may the Senate consider philosophy and ideology, we must base our decision on the effect the nomination will have on future decisions, every future decision of the Supreme Court. There is no immutable standard contained in the Constitution or any other law for senators to look to when they are facing the responsibility before us today. Neither approach described above, in my opinion, is right or wrong. The framers of the Constitution left the decision to each individual senator based on his or her own conscience and sense of responsibility. I'll base my decision on you, Judge Bork, on your ability and experience, your temperament, your integrity, and whether or not I believe you will decide the cases before you based on the Constitution the statutes before you, the regulations, and to some extent, the traditional interpretations of those items. I'd be opposed to any nominee whose intention are to ignore the precedent of the court and lead it in a radically new direction. I must be satisfied that in the guise of what you represent and Attorney General Meese call judicial restraint, that you, Judge Bork, are not a conservative judicial activist bent on imposing your own political philosophy on the court and on this nation. It is obvious, Judge Bork, that you have an extreme intellect. Your experience as a lawyer, as Solicitor General, as a law professor, and as a circuit court judge is very impressive to anyone. I've been told by many mutual friends that you enjoy a wit and a sense of humor and congeniality with your other colleagues from what I have and on this nation. It is obvious, Judge Bork, that you have an extreme intellect. Your experience as a lawyer, as Solicitor General, as a law professor, and as a circuit court judge is very impressive to anyone. I've been told by many mutual friends that you enjoy a wit and a sense of humor and congeniality with your other colleagues. From what I have read about you, Judge Bork, I believe I would be pleased personally with your views on the criminal justice system, the right of the government to prosecute criminals swiftly, firmly, and finally. The question is not whether I agree with you, Judge Bork, more often than I disagree. I will not prepare a scorecard of your decisions and vote according to the previous hit and misses that you and I make. If I were to do this, I might find the score in your favor. But this is not a game. There's no next day for the loser in the Supreme Court. The question that I will ask myself at the end of these confirmation hearings is whether I'm comfortable with the approach that you take in applying the Constitution and federal laws to the facts presented to you. Do I believe that faced with the difficult decisions with wide-ranging implications that you, Judge Bork, will listen carefully to the arguments on both sides and then apply the appropriate law in an objective and unbiased way? Or will you find an intellectually supportable and highly articulated way to decide the case as you see fit and how you feel it should come out? In my opinion, we have had too many result-oriented Supreme Court justices. I spent the last several weeks reading many of your opinions, your law review articles and speeches. I've read comments and analysis by experts and commentators on both sides of this issue. In addition, I've talked to literally thousands of people in Arizona and outside my state. I've identified the areas that concern me, and I will not review those now at this time, ask that they be included in my full statement, but I will go into some detail. The ultimate question that I must decide is whether I feel secure putting our individual liberties, freedoms, and the future of our country in your hands. History will tell us if a justice confirmed by the Senate is truly what our founding fathers had in mind when they created our system of checks and balances. I intend to do all I can to determine if you, Judge Bork, measure up to that high standard established by the founding fathers. Thank you. Thank you, Mr. Chairman.
Thank you very much, Senator. Senator Grassley. Thank you, Mr. Chairman.
Judge Bork, I'd like to be the first, or at least first, to add my welcome before I start to you and your family as you appear before this committee again. And I know you too are eager to use your appearance as a way to address the many questions raised about your nomination. And of course, I'm eager to hear your views as well. It is often said, and I think correctly so, that one of the Senate's most important functions is that of reviewing the President's nominations to the Supreme Court. Sadly, I believe this important function has been demeaned. Your nomination has been turned into a real life and death battle among the direct mail giants of American lobbying. The intense lobbying has transformed this nomination into the legislative equivalent of a pork barrel water project. All strong-arm politics, no substance. The partisans who act as the generals in this war of mudslinging have had some success. In fact, some members of the Senate have outflanked each other for the honor of taking the most extreme position even before the first day of the hearings. I think such positions are as intemperate as they are premature. It puts the judgment ahead of the inquiry, precisely the kind of closed-mindedness that some accuse this nominee of having. These remarks are remindful of the famous passage from Alice in Wonderland, where the Queen of Hearts said to Alice, "Sentence first, verdict afterwards." Now, I'm just one of 100 senators, but I'm here to say at the outset of these hearings that I've found much of the furor of the past 2 months deplorable. I'll bet this intellectually empty debate over a Supreme Court nominee would, of course, come as a very big surprise to at least one of our Constitution's founders, Alexander Hamilton. Hamilton was, of course, the first to articulate the vital power of judicial review, and he did that in Federalist 78. At the same time, however, he recognized that the judicial branch was to be the weakest of the three departments. And in his words, the judiciary was supposed to have neither force nor will, only judgment. The framers, such as Hamilton, expected that choices among competing social values would be made by the people's elected representatives, not by the unelected judiciary. Perhaps this furor during the summer of 1987 only confirms how far the judiciary has drifted from its original purpose of 1787. It is no exaggeration to say, especially in this year of the bicentennial of our Constitution, that the existence of constitutional government in America hinges on the capacity and the willingness of the Supreme Court to interpret the Constitution consistent with its true intent. Accordingly, it is our awesome responsibility to ensure, and as best we can, that a president's nominee to the Supreme Court possesses this capacity and willingness. Beyond the mere resume of this nominee, outstanding as it may be, he is not qualified to serve as a justice, in my view, unless he is willing to exercise self-restraint. Self-restraint which enables him to accept the Constitution as his rule of decision. Self-restraint which makes him resist the temptation to revise or amend that document according to his personal views of what he thinks is good public policy. Former Chief Justice Stone identified this duty of the court when he remarked in U.S. versus Butler in 1936, and I quote, that while the unconstitutional exercise of power by the executive and legislative branches of government is subject to judicial restraint, the only check upon our own exercise of power is our own sense of self-restraint. Now, judges have no license to toy with the Constitution as if it were their personal plaything, rather than the precious heritage of all Americans. As Justice Frankfurter wrote in his majority opinion in Ullman versus U.S., and I quote, "Nothing new can be put into the Constitution except through the amendatory process. Nothing old can be taken out without that same process." Unfortunately, a new generation of judges seems to have forgotten that they are appointed, not anointed. These judges, including some who have served on the Supreme Court, have demonstrated an impatience with the democratic processes upon which our nation was founded and on which it has flourished. Instead, they would abuse the power of judicial review to impose their own view of wise public policy. They would prefer to act as scientists who use some kind of judicial alchemy to transform the words of the Constitution into meanings contrary to its plain reading or intent. I am unalterably opposed to this kind of judicial arrogation of legislative and executive functions. I believe that judges must give full effect to values that may be fairly discovered in the text, language, and history of the Constitution, and of course apply them to modern conditions. But unelected and unaccountable judges should not freely overturn the legitimate policy choices of the equal elected branches solely because of personal preference. That's why the Founding Fathers, such as Alexander Hamilton, referred to the judiciary as the least dangerous branch. And that's what judicial restraint is all about. The nominee before us today has weighed in many times against the kind of judicial activism that tends to create rights not granted in the Constitution or the statutes. Frankly, his view that judges ought to confine themselves to interpreting the law rather than advocating their own ideas of wise public policy is very appealing to me. I am anxious to hear more of these views to see if they follow in the tradition of restraint practiced by Frankfurter, Holmes, Brandeis, Stewart, Powell, and a few others. Along the way, I expect that opponents of this nominee will likely focus on specific views or decisions that they disagree with. I urge my colleagues to keep their eyes on what I believe to be the real issue in this confirmation debate. And the real issue is the extent to which judges should respect the decision-making of the elected representative branches of government. Make no mistake about it. The critics of this nominee know the law they prefer is judge-made and therefore susceptible to change by other judges. Their loud protests underscore that the law they prefer isn't found in the Constitution or the statutes. If their views were found in the democratically elected law, they would have no fear of any new judge pledged to live by the credo of judicial restraint. Instead, these critics prefer judges who will act as some kind of super legislature, who will give them victories in the courts when they lose in the legislature. Judge Bork, I look forward to learning more about you from your own words in the next few days. Having identified my standard of review for this nomination, I'd like to turn to a much debated point, and that is the Senate's proper advise and consent role for this nomination. Traditionally, the Senate's role has been a very limited one. The Senate has not made a nominee's political philosophy the test for confirmation. For example, it's universally acknowledged that judicial nominees shouldn't be asked to commit themselves on particular points of law in order to satisfy a senator's politics. I can illustrate the Senate's usual advise and consent standard with some passages from the nomination hearing of Justice O'Connor. As our now chairman, Senator Biden, said, and I'd quote, "We are not attempting to determine whether or not the nominee agrees with all of us on each and every pressing social or legal issue of the day. Indeed, if that were the test, no one could be passed by this committee, much less the full Senate," or as Senator Kennedy stated at that same time, and I quote, "It is offensive to suggest that a potential justice of the Supreme Court must pass some presumed test of judicial philosophy. It is even more offensive to suggest that a potential justice must pass the litmus test of any single issue interest group," unquote. Or Senator Metzenbaum, who at the same time said, and I quote, "I come to this hearing with no preconceived notions. If I happen to disagree with you on any specific issues, it will in no way affect my judgment of your abilities to serve on the court, unquote. I might add that I very much agree with every one of my colleagues in these statements on the Senate's role. Each of these views carefully recognizes that the power to give advice is not the power to decide the issue. From George Washington to Ronald Reagan, the President has enjoyed a range of discretion in nominating Supreme Court judges. And since 1894, the Senate has deferred to the President's choice in all but 4 cases. The Senate should refuse its consent only when the President's discretion has been abused. Giving the Senate the last word without such deference would mean the Senate has the only word. This constitutional power the framers did not give to us. Of course, in the absence of constitutional power, raw political power can fill the vacuum. I will stipulate right now the ability of a handful of my colleagues to block this nomination, but I believe it would be the wrong way to approach this serious Senate duty. The dangers of politicizing the nomination process are exceeded only by its short-sightedness, because, after all, presidential elections and Supreme Court nominations come and they go. I urge my colleagues to resist the clarion call of raw politics that undermines the independent judiciary contemplated by Article 3 of the Constitution. Now, in closing, if my colleagues cannot resist the use of bald political power, I would at least hope that they have the courage to shed the fig leaf behind which they hide their real agenda. Thank you, Mr. Chairman.
Thank you. And I urge my colleagues to stick as close to the 10-minute rule as you can. I don't want to have to start to impose, as all other committees do, a rule by the clock. That statement was an eloquent 20-minute statement. And previous statements have been almost as long. So please keep within the 10 minutes. It seems I always say it to the people who are keeping within the 10 minutes, but I'm going to start to enforce the 10-minute rule. Otherwise, as moved by all our statements that Judge Bork, I'm sure is, none of us will get to have any lunch. So please.
Thank you, Mr.
Senator
Chairman.
from Vermont, Senator Leahy.
I'm delighted to have the admonition. I'm also pleased to welcome Judge Bork to the Judiciary Committee this morning, and your family. We arrived in the U.S. Senate today at a moment that is really unique in our system of government. 200 years ago, in fact this week, the delegates of the Constitutional Convention completed their work with a fantastic document that has helped this country flourish for 200 years since. I think not the least of their achievement was the method established for choosing the leaders of the judicial branch of government. The authors of our Constitution recognized that this decision was far too important to leave to the unfettered discretion of either of the other 2 branches, and said they had to be shared by them. And so our proceeding this morning, or this noon, really joins the interests of all 3 branches of the national government in one place. And the goal of the process we begin today is the conveyance of the guardianship of the Constitution. It's a solemn moment, but it's also a moment that teaches much about the system of government established in Philadelphia 2 centuries ago. I suppose this confirmation hearing is going to have some aspects reminiscent of both a trial by ordeal or even a graduate seminar on constitutional law, but it's not going to be either. It's going to be an opportunity for Americans in the bicentennial year of the Constitution to see the Constitution in action. And I hope Americans are going to be proud by what they see. Confirmation proceeding formally begins today, but it's really been underway for weeks. In fact, one prominent feature of that process so far has been an interesting debate on the role of the Senate in carrying out its constitutional duty to advise and consent. And the focus has been on the role that the nominee's judicial philosophy should play in the Senate's consideration of the nomination. Now, I believe that judicial philosophy should play a central role. And Judge Bork, you and I have already discussed that matter. After all, as a final arbiter of what the Constitution means, the Supreme Court is the ultimate guardian of the liberties of every American. There's no question that the nominee who is confirmed to succeed Justice Lewis Powell is going to be uniquely influential in determining the direction of the Supreme Court's interpretation of the Constitution for many years to come. There can hardly be an issue closer to the heart of the Senate's role than a full and public exposition of the nominee's approach to the Constitution, to the role of the courts in discerning and enforcing its commands. Now, that's my definition of judicial philosophy. And because I believe that judicial philosophy is so important, I devote an awful lot of beautiful summer days up in Vermont to an effort to learn and understand the judicial philosophy of Robert Bork. In fact, everywhere I went in Vermont, throughout the month of August, I had people come up to me and speak either for or against this nomination. In fact, I heard more about this issue than any issue in the 13 years that I've been in the U.S. Senate. In fact, Judge Bork, during the few days that you and your wife got a chance to be also in Vermont, you probably heard a little bit about it too. Now, I don't claim to understand Judge Bork's judicial philosophy completely, but having spent time immersed in his writings, his speeches, his articles, his judicial decisions, his interviews, his other works, has told me a lot about the nominee's conception of the Constitution and what it will mean for the Supreme Court and for our nation if Judge Bork is confirmed. Now, he sharply criticized some of the views of what he describes as the intellectual class, but even though he's done that, it's clear to me that Robert Bork is an intellectual of the first order. He's a thinker. He's a philosopher. And he comes before this committee with a more comprehensive and clearly expressed judicial philosophy than any nominee to the Supreme Court in recent history. And that becomes really the good news and the bad news, depending upon which side somebody might fall in this nomination. America's Supreme Court justices have taken many paths to the high bench in that beautiful building that's just a block from here. But for the most part, the justices have ascended to that bench as a culmination of careers as a practicing lawyer, or as a jurist, or as a high-ranking government official. But Judge Bork's been all three of these things at one time or another. And if he comes confirmed to the Supreme Court, he also comes as a distinguished legal philosopher as well. But his philosophy is distinguished in another way. Besides its comprehensiveness and clarity, it stands apart as a record of consistent and forceful opposition to the mainstream of modern constitutional jurisprudence. I doubt that any other nominee to the Supreme Court has ever come before this committee with a record of such unremitting and relentless opposition to the directions that the court has taken on such a wide range of issues that touch on the basic freedoms of American people. In article after article, in speech after speech, Judge Bork has criticized the constitutional decisions of the Supreme Court, not once, not a few times, not a dozen, but in scores of decisions. He's called these decisions unprincipled, intellectually empty, and even unconstitutional. His targets have included the court's major decisions in areas as important as free speech or the right of privacy or equal protection of the laws. Now, in the writings I've read, Judge Bork denounces these decisions emphatically, definitively, quite often eloquently. But the eloquence of his presentation shouldn't obscure a central fact. He believes that the Supreme Court has taken the wrong path. And more precisely, he believes that the court has wandered off the path into a trackless wilderness far from the signposts erected in our written Constitution. In fact, he has been consistent and clear and eloquent. And I think that that consistency has also attracted him to the President and the Attorney General in this nomination. But I'm troubled by the record of Judge Bork's philosophy as I understand it today. I'm struck by the breadth of his opposition to established precedent ranging from broad constitutional matters to narrower questions of the antitrust laws and other statutes. I'm disturbed by some of the interpretations that he proposes for the majestic but general phrases of our Constitution, freedom of speech and liberty and equal protection of the laws. And I'm concerned about the consequences of his philosophy. The decisions of the Supreme Court shape in large part the contours of our freedoms. Even the familiar contours of freedoms long established in the court's precedents can be changed as the power to shape them changes hands. And so we must be concerned about the shape our freedoms will take if the Senate agrees to give this nominee, whose judicial philosophy is so critical of so many precedents, a pivotal portion of the power to overturn them. But I'm also aware that the perspective I've gained so far on Judge Bork's judicial philosophy is incomplete. Times change, and sometimes do the beliefs of men and women who lived through those years. I hope that through these hearings we can learn more about Judge Bork's judicial philosophy. I know his views on some issues have changed over the years. And I'll be interested to learn whether and how his views on some of these fundamental constitutional questions have been refined or modified or even abandoned. I look forward to the testimony of the distinguished scholars and lawyers and other witnesses before this committee who studied the philosophy far more extensively than I have. But I'll be most interested in Judge Bork's own testimony on these questions because he really is the one who can speak most eloquently, most completely, and I believe most honestly to his own philosophy and his own idea of the role of a Supreme Court justice. So we welcome you to the hearing. If you don't know exactly what to expect in the confirmation process, well, you're not totally alone. There's some things we can say with certainty about this proceeding. It's going to be long, it'll be thorough, it'll be informative, and I know I voice the sentiments of every member of this committee when I say it will be fair. We really want it to be. And speaking as one senator, I can tell you they'll be approached with a seriousness and a thoughtfulness that befits its status as one of the most important duties of the United States Senator. In closing, let me just say one other thing. We have an awful lot of hearings up here, confirmation hearings. In 13 years I've been here, there have been hundreds of them. Everybody from military officers to cabinet members to Supreme Court justices. And almost 90 to 95% of the time, those confirmation hearings simply provide a record because the person is confirmed either unanimously or overwhelmingly afterward. The confirmation hearing fulfills the constitutional role, but it really doesn't change anybody's minds. In your case, it will. I think this confirmation hearing will be one of those rare instances, certainly in my lifetime, where a confirmation hearing has determined whether a nominee will be confirmed or not. And so I think this hearing takes on a seriousness and importance to you as an individual, but to the country even more so than virtually any hearing in my lifetime, and certainly in the time that I've been here in the Senate. Thank you, Mr. Chairman.
Thank you very much. We have five if I count myself, people to speak. If we keep it to 10 minutes, we can finish by about 10 after. I will withhold my statement until we come back, and I will tell those who need to make plans now we'll not reconvene until 2:30 when we come back. Senator from Pennsylvania, Senator Specter.
Thank you, Mr. Chairman. Judge Bork, I join my colleagues in welcoming you here. At the outset, I compliment you for being available for discussions with Judiciary Committee members in a somewhat different way than prior occasions. As we know, there are informal sessions, and when we met, you were willing to discuss at some length your approach to constitutional law. And one of the threshold questions which you and I discussed was whether you thought it appropriate to deal with the question of judicial philosophy. And at that time, you said you did, and we then had extensive discussions on issues of judicial philosophy, and I believe that that is very helpful. It may be that in your own situation, having written as prolifically as you have, that there was so much fat in the fire, so to speak, to be discussed. But I think that this confirmation hearing may set a precedent. And some of us were concerned about the hearings last year involving Chief Justice Rehnquist and Justice Scalia in terms of the inability to get to some of the issues. So I think that it is very useful, both for your confirmation hearing and for the process generally.
Driving hub of industry.
In my own mind, a good bit of the issue turns on whether many of your prior writings constitute professorial theorizing or represent established judicial positions that you would vote if you were on the Supreme Court of the United States. And as I read your prior writings, they are at sharp variance with justices from Oliver Wendell Holmes to William Rehnquist. They are in agreement with many justices, but as I see it, there are significant variations. The Equal Protection Clause, for example, where you have written applicable only to race and have stated in later speeches that it is race and perhaps ethnic matters, which is at variance with what the court has decided for more than a century, extending equal protection to aliens and to women and to indigents and to illegitimates and to others. The issue of due process is a very important issue. The one of freedom of speech and your writings at variance with the Holmes standard for clear and present danger. Those are some of the issues which I believe are important. I think that the matters which have been raised really in your writings span the spectrum of constitutional issues, and I think it would be useful to have extensive discussions as to your view of the Constitution. And for me, the test is whether you fit within the tradition of U.S. constitutional jurisprudence. And I come to these hearings with an open mind, and I'm prepared to listen to your views on these subjects and to make a decision based upon what I hear significantly in this room. Your prior background can't be ruled out, and what I have read about you and what I know about you and your opinions and your speeches and your law review articles are of course important. But I think the central issue is what you will testify in this proceeding. On the issues which I have raised so far, my sense is that the President is entitled to appropriate deference in his selection of a Supreme Court nominee. And I'll be interested in your view on that philosophical question as well. There is another subject which may present a somewhat different issue, and that turns on the matter of the conflict between the executive and legislative branch, Articles 1 and Articles 2 of the Constitution. And there are many issues where the President and the Congress differ historically and differ today. For example, on the War Powers Act, or for example, on independent counsel, or for example, on congressional oversight of covert action. And there you have written extensively, and there is a question in my mind as to whether your own views would tip the scale inordinately in favor of executive control. And I am not sure, and I have seen no writings on this subject as to whether the traditional deference which the Senate gives to executive appointing power would be applicable in that range. Because the court, of course, is Article 3 of the Constitution. And that's a subject which is of real concern to me, one that I've thought about, one that I will seek your opinion about. The writings which you have undertaken have been extensive. One of the professors has criticized you for campaigning for the Supreme Court, going from podium to podium, making speeches. It may be that in this group that's quite a commendation. That's what we do all the time, go from podium to podium, and I frankly find no problem with that. The real issue is one of interpretation of the Constitution and where you stand. The comments which you have made have been colorful. There has been a certain quality of toughness, perhaps, of biting quality, and I think we will be interested in some of those matters in terms of your approach, some acerbity in some of the things which you've had to say about the court. One of the comments which I found particularly intriguing was one of your references, and this is an old law journal article, but I think they're relevant to talk about. I don't weigh them too heavily, but I think they're relevant, where you referred to the Supreme Court's, quote, institutionalized role as perpetrator of limited coups d'etat, unquote, and you suggested that the court was no more, quote, legitimate than any other institution, close quote. So, pick up the quote again, if the court will not listen, why not argue the case to some other group, say the Joint Chiefs of Staff, a body with a rather better means for implementing its decisions? An interesting approach. And it may be that so much of what is in your writing is hyperbole, and something that a justice or a professor would have to write about to attract attention. We know in the Senate people think that we have great platforms, but very frequently we think nobody listens to us, and probably they shouldn't listen to most of what we have to say. So perhaps what you have written, which appears to be at variance with established constitutional doctrine, is such hyperbole. And those, for me, are the issues which are presented here and the matters which I will focus on when my turn comes to question and the key factors upon which I will make my decision. I yield back the balance of my time.
Thank you very much, Senator, and I appreciate that. Senator from Alabama, Senator Heflin.
Mr. Chairman, often in these hallowed halls we say we're engaged in a historic process. Such statements, sincerely made, are sometimes true. Seldom, however, do we stop to think of the significance of those statements, and I would propose that we do so today. Today we are participating in a process to determine the fitness of the nominee to become an Associate Justice of the highest court of our land. This process, historic as it is, has meaning for men and women 10 years from now, 20 years from now, and even into the next century. For judicial opinions have real consequences for real people. Judicial confirmations likewise have real consequences for the men and women of America. Even though the proceedings of the Supreme Court are not televised, the Supreme Court is the people's court. While it deals on one level with abstract legal propositions, standing, rightness, due process, and the like, the court at heart deals with people, their rights, their liberties, their property, their disputes and grievances, and their means of redress and resolution. There's not a single case that comes to the court which in some manner does not involve or affect people. My point is a simple one, and is one that underscores the importance of the position, Judge Bork, to which you've been nominated. Judicial opinions rendered in real cases and controversies involve real people and have actual consequences. They determine where and with whom people may live, and the legal limits of permissible activity in which people may engage. They determine where and with whom children may go to school, what textbooks they may use, and what, if any, prayers they may pray. They determine the rights of people to be secure in their homes, properties, and thoroughfares, the right of all people to enjoy the fruits of their toil and the pursuits after happiness. They determine the rights of victims and the rights of the accused. They determine delicate questions of personal privacy. They also determine what books we may read, what movies we may see, and by result, though not intent, what stories the press may cover and how they may cover them. These hearings are about justice, about the rights of individuals and the rights of society as a whole. In essence, equality under the law. The question then for us is whether the ends of justice will be further served or disserved by our vote for or against confirmation. Let us be intellectually honest with ourselves and with the American people. Let us put out on the table, get out in the open those things we hear, those allegations made in the media, and the letters, telegrams, and the phone calls we receive. Let us air all of the arguments, pro and con, about this nominee. We are told by some that Judge Bork is a brilliant man, an erudite scholar whose credentials, experience, and fundamental integrity are beyond question. We are told by others that Judge Bork is intolerant, that he will personally be responsible for the court's rolling back the clock on advances in the areas of individual rights, racial progress, and personal privacy. We are told by some that Judge Bork will strictly construe the Constitution, eschewing activism and interpreting the law, not substituting his personal opinion for what the law should be. We're told by others that Judge Bork is an extremist, an ideologue of the first order, a legal zealot who will use his position on the court to advance a far-right radical judicial agenda. We're told that President Reagan is entitled to have his nominees confirmed unless they are incompetent or dishonest. We're told by others, however, that President Reagan made his choice on the basis of ideology, which some contend is an impermissible criterion. Still others say if ideology is a permissible criterion for the president, then it is a permissible factor for the Senate to consider in evaluating this nomination. To all of Judge Bork's sponsors and supporters, I say, come forward. Let us have the evidence about competence, tolerance, and fairness. To all Judge Bork's critics and detractors, I likewise say, come forward. Let us have the evidence of incompetence, intolerance, and unfairness. While the hearing process must be comprehensive and complete, there is nevertheless one area of inquiry which should be approached with caution, and that's in the area of the nominee's religious beliefs. There are those who charge that Judge Bork is an agnostic and a non-believer. These critics contend that such beliefs will affect the opinion of the courts and hence our churches, our synagogues, and ultimately our lives. While voicing concerns about the propriety of a religious test, some critics contend nevertheless that this is a legitimate area of inquiry, for in determining the fitness of a nominee, they argue one must look to the total man, his reasoning process, and the reaches of his values. However, let me remind my colleague that Clause 3 of Article 6 of the Constitution of the United States clearly provides that no religious test shall be required as a qualification to any office or public trust under the United States. This clause, as well as the spirit of the Freedom of Religion clause in the First Amendment, should be carefully observed in pursuing any inquiry, whether it be legitimate or not, as to one's personal religious feelings. I can say with great conviction three things. Judicial activism of the right is to be dreaded, sure as much as activism of the left. Violence to the principle of stare decisis and a result-oriented rush to a predetermined outcome is to be feared, surely as much as violence in the streets. An ideological predisposition or worse, commitment to roll back the clock on individual equality and personal liberties is abhorrent to our now fundamental precepts of a fair and just society. Judge Bork, if the committee is convinced that you will balance society's need for law and order with individual rights and personal freedoms, that your jurisdiction is deferential to elected bodies, and that you don't have a proclivity for activism, then your confirmation chances are enhanced. However, if the evidence shows that you are intelligent but an ideologue, a zealot, that you are principled but prejudiced, that you are competent but closed-minded, then there is considerable doubt as to whether you will be confirmed by the Senate. Having said all of these things, we do not at this stage know what the evidence will adduce. Therefore, to all of my colleagues and to our respective constituents, I say let us not prejudge. Let us hear the evidence, analyze it, weigh it. I've spoken of feared and dreaded judicial maladies, but the worst judicial or legislative disease is a closed mind. In determining the fitness of this nominee, let no mind be closed by either blind party allegiance or rigid ideological adherence. Let no senator approach these hearings with anything less than an awesome sense of responsibility to do what is right in his or her mind. We each must follow the mandates of our conscience. A vote to confirm or not to confirm this nominee is more than just a vote. It is a reaffirmation of our commitment to the Constitution, to equality, to a stable democratic society, to liberty, to justice. Let the hearing process begin. Let the record be made. Let fairness prevail. Let justice be done. Thank you, Mr. Chairman.
Thank you, Senator Humphrey.
Thank you, Mr. Chairman. Before leaving New Hampshire last night, I was interviewed by a television reporter on the Bork nomination, and the reporter asked me a number of questions. And one of those questions, notwithstanding the seriousness of these hearings, one of those questions made me laugh, and it was this question. Senator, has the Bork nomination gotten wrapped up in politics? Boy, has it ever. I've been around this city for 9 years, and the charges against Judge Bork are the worst infestation of politics this senator has ever seen. How else can you explain the fact that 5 years ago, the United States Senate unanimously confirmed Robert Bork, this very man, to the second most important court in the nation? And now in 1987, 5 years later, some senators are acting like they have amnesia about their own voting records. So it's either amnesia, it seems to me, or it's politics. It's got to be one or the other. And then there are some special interest groups with their loathing for a man who believes in judicial restraint, fearful of a judge who believes controversial questions ought to be left to democratically elected legislatures, except where there is a violation of clear meaning of the Constitution. To listen to some of these groups, you get the impression that Judge Bork is an extremist, a racist, a sexist, indeed an arch enemy of the Constitution. Funny thing about this alleged extremist, he's a judge. This fellow Bork is already a federal judge, a high judge, a judge on the Circuit Court of Appeals for the District of Columbia. Most experts, there are certainly a lot of them when it comes to the law, most experts regard that court as the second most important in the nation, second only to the Supreme Court in its importance. So this fellow Bork, this embodiment of evil, if you believe some of his critics, is a very high judge. And guess who confirmed him judge to the second most important court in the country? The Senate of the United States, that's who. We did it. We made Robert Bork a judge 5 years ago by a unanimous vote, not a negative vote among them. So the question I have is this: if Robert Bork is the arch enemy of the Constitution, alleged by his critics, if he's an extremist, a racist, a sexist, then where in the world were all of the United States senators who voted to confirm him 5 years ago to the D.C. Circuit Court of Appeals? Were they asleep? Were they hallucinating? Were they not paying attention? Were they irresponsible? Didn't they care? Or are they just a bunch of racists and extremists themselves? I say to those who have raised vicious charges against Judge Bork, come off it. Come off it. You insult not only Judge Bork, but the United States Senate as well. We do not in this body confirm ogres and misfits to the federal bench. Now about the nominee. The first thing I want to point out is that Robert Bork doesn't need to take all this guff. We ought to be mighty grateful to him and to his family for their willingness to submit themselves to the gutter snipe gang who've had such play in recent weeks. Here's a man who's brilliant, attended the University of Chicago Law School, elected Phi Beta Kappa. He could be earning $1 million a year, easily. He had it made. He was in with a prestigious law firm, and then he threw it all overboard to go off to Yale Law School and teach law. Professors don't make that much money, but he saw it as a higher calling. Even after 11 years of teaching, he took time out for yet an even higher calling, serving as Solicitor General of the United States, the third highest office in the Justice Department. And he served exceedingly well there under exceedingly trying circumstances. And then back to Yale Law School for another 4 years. And then he was nominated and confirmed unanimously by the United States Senate, let us remember, to the second most important court in the country, the Circuit Court of Appeals for the District of Columbia. And there he has compiled the most remarkable and exemplary record. Robert Bork has served his country well, 2 stints in the United States Marine Corps, to serving as a high official in the Justice Department, to federal appeals court judge. Robert Bork has served this nation well. We ought to be glad that he's willing to devote his mind and his strength to teaching and to government service, because with his brilliance and his credentials, he could have been a multi-millionaire by now. The question before us is simple. Is the nominee qualified to serve on the Supreme Court? If we were looking for the ideal nominee, we'd look for someone who graduated from a prestigious law school with high grades, as did Robert Bork. We'd look for someone who taught law at a prestigious university, as did Robert Bork. We'd look for someone who served on a Circuit Court of Appeals, preferably the Circuit Court for the District of Columbia, as has Robert Bork. If you were looking for the ideal nominee, you'd look for an experienced judge who had earned accolades from highly respected authorities, as has Judge Bork. Accolades from whom? How about a retired Supreme Court Justice, Chief Justice Warren Burger, who recently said, and it bears repeating, I know others have referred to this, including, I think, President Ford, but it bears repeating. Warren Burger said, "I don't think in more than 50 years since I was in law school there has ever been a nomination of a man or woman any better qualified than Judge Bork," and that language includes Warren Burger, doesn't it? I think that's pretty remarkable. And savor that accolade for a moment. The best qualified nominee in 50 years. That speaks a lot louder to this senator than any dozen noisy special interest groups clamoring for Robert Bork's scalp. Justice Burger has no axes to grind. Neither does Justice John Paul Stevens, still serving on the Supreme Court, who said, "I personally regard Judge Bork as very well qualified, a very well qualified candidate, and one who will be very welcome addition to the court." Bork is very well qualified, according to Justice Stevens. And these are impressive, very impressive accolades to this senator, unless we're prepared to dismiss Justices Burger and Stevens as extremists, too. And Burger and Stevens are not alone in their high praise. Former President Gerald Ford was before us this morning on behalf of Robert Bork. Eminent Democrats as well support this nominee, including 2 of the highest, most senior officials of the Carter administration in the area of law, Lloyd Cutler, President Carter's White House counsel, and former Attorney General Griffin Bell, and they will be here to testify in behalf of the nominee, as will 5 other Attorneys General of the United States. So how has Bork earned the confidence of such highly respected authorities? Performance, that's how. Bork's critics will focus on his theoretical writings from as long as 25 years ago. But the real measure of Bork as a judge, not Robert Bork as a college professor, not Robert Bork as a provocative academician probing the establishment, the real measure of Robert Bork as judge is his record on the D.C. Circuit Court of Appeals. His record. Let's look at the record. It's impeccable. The Senate acted wisely when it unanimously confirmed this man to the bench in 1982. So sound has been his reasoning, so carefully crafted have been his decisions, that not one opinion, not a one, has been overturned by the Supreme Court. Robert Bork has written or joined in over 400 such decisions since he joined the D.C. Circuit Court, and not once has a decision been overturned by the Supreme Court on appeal. That's very impressive to this senator. And now we know why so many eminent authorities have such high praise for this judge. Why then the Inquisition? Why the scurrilous charges against a man whose fitness for the bench was carefully examined by this body before he was confirmed by a unanimous vote of the Senate 5 years ago? Why the salvos against a judge who has compiled an impeccable record in his opinions? I think I know the answer. The most extreme opposition to Judge Bork comes from those who consider the Supreme Court, as constituted in recent times, a convenient place to sidestep the democratic process. A judge like Robert Bork, who not only preaches the doctrine of judicial restraint but practices it as well, is a great inconvenience to those who don't trust the values of the American people. Judges like Robert Bork do not substitute their personal views for a neutral reading of the Constitution. Judges like Robert Bork do not act like legislators creating new law. Instead, they act like judges, scrupulously interpreting the intent of the framers of the Constitution and of the democratically elected legislators here in Congress and in the state legislatures. We legislators ought to be grateful for that. Judge Bork does not want to take over our turf, as do some of his brethren. I'm grateful. Judge Bork believes, along with many of both liberal and conservative persuasion, along with many present and past, that if new rights are to be created, they ought to be created by representatives of the people who are democratically elected by the people and who are accountable to the people every 2 or 6 years, as the case may be. Judges like Robert Bork believe that new rights ought not to be created by judges who are elected by absolutely no one and who, in their appointments for life, are accountable to absolutely no one. I say, long live the principle and the practice of judicial restraint. Is Robert Bork, with his judicial restraint, out of the mainstream? Over the last 5 years, he's voted with the majority in 94% of the cases in which he participated. 94% sounds pretty mainstream to this senator. Or, on the other hand, perhaps the D.C. Circuit Court is full of extremists. That isn't the answer at all, because we know that among the members of that distinguished body are many who are liberal and many who are conservative, and about an equal number who are so-called moderates. The record shows that Judge Bork voted with the majority 94% of the time. That sounds mainstream to this senator. Remember Antonin Scalia? We confirmed him last year to the Supreme Court by a unanimous vote. There were no charges of extremism against Scalia. So what? Scalia and Bork served together for nearly 4 years on the same court, and Bork voted with Scalia 98% of the time in which they both participated in cases. 98%. Does that make Scalia an extremist too? Of course not. It means instead that these charges against Bork are political poppycock. Pure political poppycock, 99 9/10% pure, so pure it floats. We'll have a good review of Robert Bork's life in the next 2 weeks. This is your life, Robert Bork. And even though we've been through all of this before and found him fit, it'll be thorough, as it should be, but let's also make it thoroughly fair, because it should be thoroughly fair as well. And I finally have to say this, that I think we've gotten off to a bit of a rocky start. By delaying these hearings a record 70 days, and by intemperate remarks and irresponsible charges by a small number of members on this panel.
Thank you, Senator. Last but surely not least, and before you begin, Senator Simon, let me suggest I would appreciate the cooperation of the audience. We have one chore to do immediately after this statement, and what we're going to do is go into executive session. If you'd all just sit for 30 seconds while we get the nomination of Judge Sessions out to be FBI director, I would truly appreciate it. If not, that police officer will shoot you on sight if you stand up. That's a joke. I'm only kidding. The senator from Illinois.
Thank you, Mr. Chairman. And Judge Bork, we welcome you and your family. It has been said accurately that what we're about to decide is going to have a great impact on this nation well into the next century. And I would differ with my colleague, Senator Humphrey, on one point. I did not happen to be here when you were approved for the Circuit Court of Appeals. I can very well visualize voting for someone for the Circuit Court of Appeals, but not for the Supreme Court. Because here you are really setting the course for the nation. Over that building, not too many feet from here, are the 4 words, equal justice under law. I want them to be much more than simply words chiseled on stone. And I say this as a non-lawyer member of this panel. I want those words to live, and I want the Supreme Court justices to make them live. I know there are a few, very few, out there who write to me or who contact us and say, let's just keep postponing so President Reagan can't make an appointment. President Reagan was elected. He's entitled to nominate whomever he wishes, and we have the equal responsibility of weighing that. I expect President Reagan to nominate a conservative. Justice Powell is a conservative. 6 of the 8 members of the court sitting right now have been appointed by Republican presidents, a majority approved by Democratic members of the Senate. I don't find the question quite as simple as some do. I think there are several questions that we have to ask ourselves and that I will be asking myself during the course of your testimony. First, is the nominee open-minded and fair? Your job is not simply to render justice, but also to symbolize justice for the people of this nation. I want to make sure that really takes place, both the symbolic role and the rendering of justice. I do not want someone with an ideological mission of either the right or the left. Second, I want a nominee who is sensitive to civil rights. I'm 58 years old. I have seen huge progress made in this nation. Not that we don't have a long way to go yet, but much of that progress has been because of the Supreme Court, of the 9 people who sit in that building over there. I want someone who's willing to lead on civil rights, not simply to someone who will be dragging his feet. Third, I want someone sensitive to civil liberties. Freedom is much easier to give away than to protect. I want someone who's going to preserve our freedom, who's willing to stand up, if necessary, against public opinion. Public opinion sometimes can be dramatically wrong. And I think of the decision in 1942 on Japanese Americans, where the Supreme Court knuckled under to public opinion. I want someone who's going to protect the liberties of Japanese Americans, of all Americans, whatever their background. I want someone who is going to protect the people of this nation also against the abuse of power by government. And we know from the experience in our country and in other countries that government can abuse that power. I want someone who is sensitive to our traditions of separation of church and state. My father was a Lutheran minister. I have an understanding of the yearnings that people have for values in our society, and I want to preserve those values. But I also recognize there are things that government can do well, like providing student aid. There are things that government cannot do well. One of those things is to promote religion. I want to make sure the nominee is sensitive to our traditions in that field. And then finally, I want someone who has some compassion. I do not expect your heart to overrule your head, but there will be marginal cases that a Supreme Court justice will have to rule on. And I want a Supreme Court justice who cares about people, just as I want a government that cares about people. That sounds like a tall order, those requirements. But I think there are people, conservatives and liberals, Democrats and Republicans, who meet that. I want the letter of the Constitution to be followed, but I also want the spirit of the Constitution to be followed. Dennis DeConcini, my colleague from Arizona, in his remarks, perhaps summarized it best. He said a few minutes ago, "The ultimate question I must decide is whether I feel secure putting our individual liberty, freedoms, and the future of our country in his hands." That is an awesome responsibility on our part and on the part of whoever goes to that court. Thank you, Mr. Chairman.
Thank you very much. I would like now to move into the executive session on the nomination of William S. Sessions of Texas to be Director of the Federal Bureau of Investigation. I believe the committee's thoroughly reviewed his background. He is extremely qualified, and I yield to the senator from South Carolina moves his approval. Is there any further discussion on Judge Sessions?
I won't take more than a moment. I want to say what a very favorable impression that Judge Sessions made before this committee. He responded to the various questions that were put to him. He indicated his strong position in terms of maintaining the independence of the Federal Bureau and to maintain that independence free from political interference. And I think he has been an outstanding choice, and I look forward to supporting his nomination.
Well, I share your sentiment, Senator. I think he'll be a fine director. I think he is independent. He answered our questions. I ask unanimous consent that the statement I have on this nomination be entered into the record at this point as if read, and without objection, and the same with any other senator who wishes to put in a statement. And the nomination of Judge Sessions has been moved by the senator from South Carolina, Senator Thurman. Second the nomination. All those in favor say aye. Aye. All those opposed. The nominee is favorably agreed to and will be sent to the floor. We will reconvene with Judge Bork, with my making a statement, Judge Bork's statement and questionings at 2:30.
And that's what has to.
Quite frankly, it might accommodate our brethren between us here if we went slightly out of order here, and I'm going to ask you to be sworn in now before I give my statement, but after I'm sworn in, I will give this, after you're sworn in, I'll give the statement. Judge, do you swear to give at this hearing, in response to questions, the truth, the whole truth, and nothing but the truth to help you God?
I do, Mr. Chairman.
Thank you. You're duly sworn. That was just to show your right hand working. Judge Bork, I'd like to make an opening statement, if I may. And I'd like to, in addition to asking the staff to settle down behind me here, I'd like to welcome you back this afternoon and personally welcome you to the Senate Judiciary Committee. You've heard much today, and we've all heard a great deal today, about the bicentennial of our Constitution. But as you and I both know, the convention in Philadelphia was only one very important chapter in the history of our people and in the evolution of our unique form of government. From that day in Philadelphia to this hour, the heart of the controversy over the Constitution has been over the basic question that is certain to animate the debate that may commence in this committee. And that is the debate between the tensions between the rights of an individual and the will of the majority. As James Madison, the father of the Constitution, said, and I quote, "The great object of the Constitution is to secure the public good and private right against the danger of the majority faction, and at the same time to preserve the spirit and the form of popular government." End of quote. Judge, the seasons have turned to centuries, and the document we now celebrate, the world's longest and oldest living Constitution for over the past 200 years, is something that we'll formally celebrate tomorrow. And for 200 years, each generation of Americans has been called to nurture, defend it, define it, and apply it. Senator Sam Ervin, our late colleague from North Carolina, was fond of reminding all of us and quoting an eloquent educator about the ties between the Magna Carta, the English Petition of Rights, the Declaration of Independence, and the United States Constitution. And the quote he used to always use was this: "These are great documents of history. Cut them, and they will bleed. Bleed with the blood of those who fashioned them and those who nurtured them through the succeeding generations." Judge, each generation, in some sense, has had as much to do to author our Constitution as the 39 men who affixed their signatures to it 200 years ago. Indeed, 2 years after its signing, following a bitter national debate over its ratification, at the insistence of the people, the Constitution was profoundly ennobled by the addition of what have come to be known as the Bill of Rights. But before 100 years would transpire, a civil war erupted over the meaning of that Constitution and that so-called Bill of Rights. A civil war which would answer Lincoln's question whether, quote, "any nation so conceived and so dedicated can long endure." And from that civil war would emerge the so-called Civil War amendments, which would settle forever the truth that all men are created equal. It gave definition through those Civil War amendments to what many thought were meant in the first instance. But before another 100 years would pass, our own century would be distinguished by hotly contested struggles to assimilate into the very fabric of the Constitution equal protection for blacks, minorities, and women. And as surely as those who waged the Civil War, those who waged the struggle for civil rights, infused the Constitution with their own vision. The story of these struggles, at its heart, in my view, is the story of what makes America and her people the envy of the world. And each of these struggles, which I've made reference to, each of these struggles and each of these times when the individual faced a recalcitrant government, the individual won his or her rights, always expanding, his or her rights always expanding. America is the promised land because each generation bequeathed to their children a promise that they might not come to enjoy, but which they fully expected their offspring to fulfill. So the words, "all men created equal," took a life of their own, ultimately destined to end slavery and enfranchise women. And the words "equal protection and due process" inevitably led to the end of the words "separate but equal," ensuring that the walls of segregation would crumble, whether at the lunch counter or in the voting booth. And so, faithful to that tradition, in the ebbing summer of our bicentennial, the Constitution must become more than an object of celebration. It is to become once again the center of a critical national debate over what it is, what it must become, and how it will be applied in a world that neither of you nor I can envision at this moment. A world of biotechnical engineering, a world of burgeoning changes in science, a world where once again the rights of individuals and the right of the government to impact upon them will be put in a different context and in conflict. And so let's make no mistake about it. The unique importance of this nomination is in part because the moment in history in which it comes. For I believe that a greater question transcends the issue of this nomination. And that question is, will we retreat from our tradition of progress, or will we move forward, continuing to expand and envelop the rights of individuals in a changing world which is bound to impact upon those individuals' sense of who they are and what they can do? Will these ennobling human rights and human dignity, which is the legacy of the past 2 centuries, continue to mark the journey of our people? And so, Judge, as you well know, this is no ordinary nomination, not merely because you are there. And I must say to you that it must be somewhat daunting, as experienced as you are, to sit there and with an array of people here about to question you. It's not an easy position to be in. I'm confident, I'm not being solicitous, you will handle it well, but nonetheless, it is not an easy position. But this nomination is more, with all due respect, Judge, and I'm sure you agree, than about you. In the passing on this nomination of the Supreme Court, we must also pass judgment on whether or not your particular philosophy is an appropriate one at this time in our history. And you are no ordinary nominee, Judge, to your great credit. Over more than a quarter of a century, you've been recognized as the leading, perhaps the leading proponent of a provocative constitutional philosophy. One that when I was in law school, I did not go to Yale. I'm not bragging about that, but I did not go to Yale. One where our constitutional law professor would say, and this is such and such, and then as Judge Bork, as Professor Bork at Yale says, you have been a man of significant standing in the academic community. And thus, in a special way, a vote to confirm you requires, in my view, an endorsement of your basic philosophic views as they relate to the Constitution. And thus, the Senate, in exercising its constitutional role of advice and consent, has not only the right, in my opinion, but the duty to weigh the philosophy of the nominee as it reaches its own independent decision. A view that I think you share, but I will ask you about that in the question and answer period. Essentially, the role of this committee, as I see it, is to provide an opportunity for your advocates and your adversaries, your opponents, the opponents of this nomination and the supporters of this nomination, to present their views for consideration as they come to the witness table at which you sit. But most of all, it's an important opportunity, and it's a required opportunity, and I and my colleagues assure you of the opportunity to fully offer your views and for members to question you on what you mean by the views that you hold. My role as chairman of the Senate Judiciary Committee, in my view, is not to persuade, but to attempt to ensure that the critical issues involved in this nomination are laid squarely before my colleagues and the American people. As I made clear when Senator Baker contacted me and when he and Attorney General Meese came to see me prior to your selection, as I told them privately, Judge, that as a matter of principle, I continued to be deeply troubled by many of the things you had written. I would have been less than honest then or now to pretend otherwise. And Judge, assuming you mean what you've written, our differences are not personal. They relate to basic questions of principle. I will question you in several areas to determine what our differences mean in terms of real cases, with real people, with real winners and real losers. For example, my areas of concern touch the relationship among people of different races in our land. Whether it was wrong for state courts to enforce covenants that prohibited black couples from buying homes in white neighborhoods. Whether the court was wrong in not stopping the United States Congress from outlawing literacy tests to protect voting rights. And whether in the future, as similar situations arise, the court will intervene to protect the rights of the races in this land. And I also touch on the basic right of privacy. Privacy in our marriages and in raising our children. Whether the government can prohibit a child from going to a private school. Whether the government can prohibit parents from having their children taught a foreign language. Whether anyone can be subjected to sterilization, be it the government of Oklahoma attempting to forcibly sterilize a thief, or by a big business which forces a woman to choose between her job and her right to bear children. Or whether the government can prohibit a married couple from using birth control, or whether in the future, as populations grow and explode, whether the government can say you may only have 2 children. And they also touch the right of free expression, be it political. For example, whether Martin Luther King could have been prohibited from advocating violation of immoral segregation laws. Or be it artistic. For example, can an American be denied the right to create and enjoy literature, painting and sculpture, dance, music, movies of their choice? I not only think it was wrong for some of these things to have happened in our country, and they did, but it's also right for the Supreme Court, in my view, to have stepped in many of the cases that I made reference to without naming them when it did, to protect these rights of individuals against the majority. From much of what I've read, and I honestly believe, Judge, I think I've read everything that you have written, and you've been very cooperative. We asked your staff, asked you to provide it, and you've literally provided us hundreds of pages of written material. Based on that material, we appear to disagree about whether the Supreme Court was right or wrong in many of these cases. And while there's plenty of room for debate about these issues, each of us must take a stand on whether or not we believe the court was wrong in these most critical decisions of our time. I believe all Americans are born with certain inalienable rights. As a child of God, I believe my rights are not derived from the Constitution. My rights are not derived from any government. My rights are not derived from any majority. My rights are because I exist. I have certain rights. That they're given to me and each of my fellow citizens by our Creator, and they represent the essence of human dignity. I agree with Justice Harlan, the most conservative jurist and justice of our era, who stated that the Constitution is, quote, a living thing, and that its protections are enshrined in majestic phrases like equal protection under the law and due process, and thus cannot be, as he said, and I quote, reduced to any formula, end of quote. It is, as the great Chief Justice John Marshall said, intended, and I quote, intended to endure for ages to come, and consequently to be adapted to the various crises of human affairs, only its great outlines marked, end of quote. For the next 2 weeks or so, obviously only in your case, I hope, Judge, for the next couple days or so, my colleagues and I, yourself and others, will be engaged in a historic discussion that could affect the direction of our country. And I think it would be a disservice to the American people if we allowed that debate to be clouded by strident rhetoric of the far left or the far right. Such inflammatory statements only distract from the central focus of these hearings. For better than 2 decades, you have been a distinguished scholar, a man whose ideas have been debated in many constitutional law classes in this country. In your writings, you have forthrightly stated your principles. To use your own words in your published opening statement, which you haven't given yet, is my philosophy of judging is neither liberal nor conservative. When I have been asked, as I have been after having read your writings this August, whether I thought you were a conservative or a liberal, my response was just as yours. I believe you're neither a conservative nor a liberal. You have a very precise, as I read it, viewing of how to read the Constitution. And you have suggested equally forthrightly what we should examine in reviewing your nomination when you said, and I quote, I'm quoting you, you look for a track record, and that means you read any article, any opinions they've written. There's no reason to be upset about that, end of quote. I agree with you that there is a consistent thread that runs through your writings. You said just 2 years ago that, quote, you finally worked out a philosophy which is expressed pretty much in that 1971 Indiana Law Journal piece, end of quote. And your most definitive writing to date has been, as I can read it, that piece. And later you added, my views have remained about what they were. In the end, whatever my reaction or anyone else's reaction to your record, the process of confirmation is best served if we hear each other out and use this unique opportunity to educate ourselves and the American people about your record and what it may mean for the Supreme Court and to the future of this country that we both love very much. Out of respect for you, out of the majesty of the Constitution and the greatness of the American people, it seems to me we who preside in this hearing today owe no less. Judge, I would now invite you, if you would like, to make any opening statement for as long as you would like, and then we'll begin with the questioning. I thank you for your indulgence this morning and listening to all of us.
Mr. Chairman, thank you very much, distinguished members of the Judiciary Committee. I would like first, however, to introduce my family. if I may.
I apologize. I had an opportunity to meet them, and the hearing's been going on so long, I failed to mention that. Please do.
Well, one person I can't introduce to you is my mother, Mrs. Elizabeth Bork, who is, I am confident, watching on television. My wife, Mary Ellen Bork, in the gray suits. My daughter, Ellen Bork, in the burgundy. My son, Charles, and my son, Robert, Jr. And as Senator Hatch mentioned, Mrs. Potter Stewart, who's a neighbor of ours, is with us today.
Welcome all. Thank you for being here.
I want to begin by thanking the President for placing my name in nomination for this most important position. I am flattered and humbled to have been selected. If confirmed, I assure the Senate that I will approach the enormous task energetically and enthusiastically, and will endeavor to the best of my ability to live up to the confidence placed in me. I also want to thank President Ford and Senators Dole and Danforth and Congressman Fish for their warm remarks in introducing me to the Senate and to this committee. As you have said quite correctly, Mr. Chairman, and as others have said here today, this is, in large measure, a discussion of judicial philosophy. And I want to make a few remarks at the outset on that subject of central interest. That is my understanding of how a judge should go about his or her work. That may also be described as my philosophy of the role of a judge in a constitutional democracy. The judge's authority derives entirely from the fact that he is applying the law and not his personal values. That is why the American public accepts the decisions of its courts, accepts even decisions that nullify the laws a majority of the electorate or of their representatives voted for. The judge, to deserve that trust and that authority, must be every bit as governed by law as is the Congress, the President, the state governors and legislatures, and the American people. No one, including a judge, can be above the law. Only in that way will justice be done and the freedom of Americans assured. How should a judge go about finding the law? The only legitimate way, in my opinion, is by attempting to discern what those who made the law intended. The intentions of the lawmakers govern, whether the lawmakers are the Congress of the United States enacting a statute, or whether they are those who ratified our Constitution and its various amendments. Where the words are precise and the facts simple, that is a relatively easy task. Where the words are general, as is the case with some of the most profound protections of our liberties in the Bill of Rights and in the Civil War amendments, the task is far more complex. It is to find the principle or value that was intended to be protected and to see that it is protected. As I wrote in an opinion for our court, the judge's responsibility is to discern how the framers' values, defined in the context of the world they knew, apply in the world we know. If a judge abandons intention as his guide, there is no law available to him, and he begins to legislate a social agenda for the American people. That goes well beyond his legitimate power. He or she then diminishes liberty instead of enhancing it. That is why I agree with Judge Learned Hand, one of the great jurists in our history, when he wrote that the judge's authority and his immunity depend upon the assumption that he speaks with the mouths of others. The momentum of his utterances must be greater than any which his personal reputation and character can command, if it is to do the work assigned to it, if it is to stand against the passionate resentments arising out of the interests he must frustrate. To state that another way, the judge must speak with the authority of the past and yet accommodate that past to the present. The past, however, includes not only the intentions of those who first made the law, it also includes those past judges who interpreted it and applied it in prior cases. That is why a judge must have great respect for precedents. It is one thing as a legal theorist to criticize the reasoning of a prior decision, even to criticize it severely, as I have done. It is another and more serious thing altogether for a judge to ignore or overturn a prior decision. That requires much careful thought. Times come, of course, when even a venerable precedent can and should be overruled. The primary example of a proper overruling is Brown against Board of Education, the case which outlawed racial segregation accomplished by government action. Brown overturned the rule of separate but equal laid down 58 years before in Plessy against Ferguson. Yet Brown, delivered with the authority of a unanimous court, was clearly correct and represents perhaps the greatest moral achievement of our constitutional law. Nevertheless, overruling should be done sparingly and cautiously. Respect for precedent is a part of the great tradition of our law, just as is fidelity to the intent of those who ratified the Constitution and enacted our statutes. That does not mean that constitutional law is static. It will evolve as judges modify doctrine to meet new circumstances and new technologies. Thus, today we apply the First Amendment's guarantee of the freedom of the press to radio and television, and we apply to electronic surveillance the Fourth Amendment's guarantee of privacy for the individual against unreasonable searches of his or her home. I can put the matter no better than I did in an opinion on my present court. Speaking of the judge's duty, I wrote, "The important thing, the ultimate consideration, is the constitutional freedom that is given into our keeping. A judge who refuses to see new threats to an established constitutional value and hence provides a crabbed interpretation that robs a provision of its full, fair, and reasonable meaning fails in his judicial duty. That duty, I repeat, is to ensure that the powers and freedoms the framers specified are made effective in today's circumstances." But I should add to that passage that when a judge goes beyond this and reads entirely new values into the constitutions, values the framers and the ratifiers did not put there, he deprives the people of their liberty. That liberty, which the Constitution clearly envisions, is the liberty of the people to set their own social agenda through the processes of democracy. Conservative judges frustrated that process in the mid-1930s by using a concept they had invented, the 14th Amendment's supposed guarantee of a liberty of contract to strike down laws designed to protect workers and labor unions. That was wrong then, and it would be wrong now. My philosophy of judging, Mr. Chairman, as you pointed out, is neither liberal nor conservative. It is simply a philosophy of judging which gives the Constitution a full and fair interpretation, but where the Constitution is silent, leaves the policy struggles to the Congress, the President, the legislatures and executives of the 50 states, and to the American people. I welcome this opportunity to come before the committee and answer whatever questions the members may have. I am quite willing to discuss with you my judicial philosophy and the approach I take to deciding cases. I cannot, of course, commit myself as to how I might vote on any particular case, and I know you would not wish me to do that. I note in closing, though it's been mentioned by President Ford, that I've been fortunate to have a rich variety of experience in my professional career in the major areas of private practice, the academic world, government experience, and the judiciary. I have been an associate, junior partner, and senior partner in one of the nation's major law firms. I have been a professor at the Yale Law School, holding 2 named chairs, Chancellor Kent Professor, once held by William Howard Taft, and as the first Alexander M. Bickel Professor of Public Law. For almost 4 years, I served as Solicitor General of the United States, in which capacity I submitted hundreds of briefs and personally argued about 35 cases before the Supreme Court of the United States. Finally, for the past 5½ years, I've been a judge in the United States Court of Appeals for the District of Columbia Circuit, where I've written, according to my counts have varied here this morning, about 150 opinions and participated in over 400 decisions. I have a record in each of these areas of the law, and it is for this committee and the Senate to judge that record. I'll be happy to answer the committee's questions.
Thank you very much, Judge. Let me suggest to my colleagues that so people can plan when they be questioning, we would have this first round of questioning at 30 minutes apiece. And we would go in the same order with the opening statements. And then
I'll offer commentaries. Hold your horses.
Judge.
If I'm talking over Biden, can you hear me and Biden, or neither? You know what I mean? So, okay, here's the analysis. It seems like, as someone in the point chat, it could have been Matt, that, both sides are scared of, both sides seem to be scared of Bork because he doesn't hold Congress above the law. He seems to hold them to a higher standard, or maybe he even treats them slightly like second-class citizens. That came up. One of the senators had brought this up. But I was going to go ahead and end this stream. I do like the idea of finishing up Bork's questioning, and I'm going to do that. I'm filling the gaps as Congress is in and out of session, or they have days off from hearings. But, there's not much to analyze. What we had were a bunch of senators basically giving their introductions, and Bork introduced himself. And so, this is following the Scalia hearings. I think we can expect to hear a lot of the same cases come up. We're going to hear about Roe versus Wade. We're going to hear about affirmative action. We can expect to hear about, the right to privacy and some other constitutional considerations, maybe whether he believes in originalism, or I don't think that, are they even going to consider him as a living, breathing Constitution guy? I don't think so. I think they know where he stands. On day 9, we have Thomas Sowell come in. And he and Biden have an exchange. It's pretty good. That's already on my channel if you just want to skip to that. But I am going to go ahead and end this stream. I'm going to start another one very soon. And gosh, John Doe, I can't. Who wants to put up with that? Get out of here. Is there a boot emoji? Yeah. I'm just look. The chat rate is what it is. If people just want to watch, they don't want to chat. That's their own prerogative. Honestly, it's when people come in here and they start complaining, the chat rate drops. It's like they just dominate by complaining. Oh, what about this? What about that? It's like, well, what about just watching and having a conversation like the rest of us? It's like not everybody wants to chat. Some people just want to watch it. I get that. So I think there will be more analysis as we get into the nuts and bolts of the cases that come up, but I mean, not much as far as the exact. I love to chat, honestly. The cases that are going to come up, I think, like you said, they're probably the same ones in Scalia. This is only maybe even less than a year later. But with that said, keep an eye out, Matt. I expect to see you back because it was your recommendation. Let me see if I even finished. I tried to, okay, it's done downloading. Let's see if I can get that going pretty quickly. Guys, thank you for joining. I really appreciate it. And we'll see you just in a few minutes with the 2020 Kamala stream.